One second of the.
Please hold on for a minute. Yes.
My lord, there are three matters, 45, 46, and 44. 44, 45, 46. Under heading, two under heading hearing and one for admission.
44, 45 and 46. Yes, these are all labor matters.
Yes. Now, lordships can take it up at 250 and at 1250.
Where is the other side? Where is the other side?
Lord, I am appealing on behalf of.
Are you ready?
Lord, the council is appealing to me.
Are you ready? I
Lord,
will
sir.
hear it
We are
fully.
prepared. Lord, sir, I am prepared.
You are prepared, no?
We are prepared.
Why are they related to each other?
Your lordship, one of them, that is 44,
Yes.
that is a different matter. That is with regard to the finding of the labor court that the inquiry was unfair and consequently the dismissal was bad.
Then why are you mentioning all the three matters?
Your
Is it
lordship,
related to 45?
no, and 44, 45, they are related. They are the
44
same.
and 45 are related.
Sorry, 45 and 46 are the same.
You want to do all the matters?
45 and 46 in my submission, your lordship, will take hardly 5 minutes.
Okay. So first we'll take up 45, 46.
Your lordship.
And then we'll switch over to 44.
Correct. Because
Have
in
you prepared any
those
notes?
two, I am the respondent, but I have a preliminary issue that they have become infractuous and virtually they, in the counter they have accepted that they have become infractuous.
We'll, just after the bail matters, I'm likely to complete the bail matters very soon, maybe within an
I'm
hour.
wait. I'll
Lord,
Within
the
an hour, I
idea
think.
only one of the matters is here 45.
So,
44 and 46 I am not appealing.
how does that make a difference? Parties should be there to argue. Record will help. Have you prepared any notes?
I am not, because I am for the respondent. The issue is very simple.
After the bail matters.
The lordship permission matters. Second appeal one of 26 lordship please to reserve judgment.
Yesterday also it was mentioned.
We
You are
are
mentioning
filing
it again.
the IA lordship. Lordship may kindly
It can't be. You just wait. We are in the
Lordship,
process.
today the matter is fixed
We just
for
do
the
not know. It can't be
court
like
will
this. No,
execute the decree.
they will not.
Absent will be evicted from the premise.
No, no. It can't be like this. You see, the judgment is reserved. Don't put pressure on the court.
I understand.
Right? Don't pressurize the court, and every day you are
They are not
mentioning.
doing so because the current executive court is not
No.
accepting the submission which is advanced by us that the matter is pending to this honorable court. They are
If they
advanced.
reject your application, you file a review petition. You have a remedy. I'm not here to provide you the remedies.
They are saying that there is no stay in the matter, so they are proceeding.
Yes, the judgment is reserved. I will take my own time to pronounce the judgment. I can't be in a haste in a second
I
opinion.
understand.
So you better understand.
From supplementary list, progress filing item 1, PA 1550 of 2026.
After a week on instruction of Mr. Rahul Ranjan, he is not there. After a week,
How has that come up today? In the
Yesterday
supplementary
it was
list?
listed, and no one appears on behalf of the petition, therefore it was adjourned for this.
And today you are sitting time. Why nobody was there yesterday?
not very often. और उसका medical कुछ happening.
B number 1550 of 20.
My prayer is not, in the meantime, make also the strictest from the concern. It is a matter of the 2008 law. And it is a matter of the 304B and 498 with regard to the complaint case. And
Status of what? This is a complaint case.
हाँ तो कॉग्निजेंस हुआ उसके बाद क्योंकि 2008 से
कॉग्निजेंस तो 2022 में हो गया.
हाँ उसके बाद क्या क्या हुआ
मतलब आपको समझ नहीं आ रहा है. कंप्लेंट केस 2008 में फाइल हुआ. उसके बाद क्या हुआ केस में?
इसमें तो ऐसे वगैरह हुआ है जो एक लगाए हैं
हाँ।
पिटीशन में बाकी और
उसके बाद क्या हुआ? रिकॉर्ड गायब.
क्या हुआ, इसीलिए तो हम माय क्वेरी उसमें स्टेटस में आ जाएगा कि क्या हुआ नहीं हुआ, क्योंकि we cannot call
Office, the case arises out of complaint case number 1766 of 2008. Counsel for the appellant seeks adjournment. Counsel for the state submits that the status of the case may be called for, and it is not clear as to why the case remained pending since 2008. Office is directed to call for the entire order sheet of complaint case from the concerned court. Post on 9th April.
Daily, it's again on the same.
19 पर हम adjournment नहीं लेते.
From daily list for first filing item 2, DA.19.07.2025 of 2026.
We have already fixed some case, right? Also for the petitioner seeks adjournment. Tomorrow demands.
No, I was just after 2 cases.
You see, you can't have it both ways, right? We have fixed certain cases. Senior counsel has come from outside.
I have received the file.
Very good. Thanks. You want to argue? Very good.
The FIR was registered against unknown persons under section 3032 of BNS, which is 379 matters. This bail application was earlier withdrawn matters, dismissed as withdrawn. There were several other court-used persons of matters. The allegation is that the informant says that his truck was stolen. In another case, from the confession of the court use, my name came that I helped him steal the truck. And from that court use, Shyamlal Mehta, 5 trucks were seized matters. So even that Shyamlal Mehta has gotten bail matters, and now all the other abused persons have also got bail. It's just
The review order reveals that on your confession, some raid was conducted in the premises of Rajul Sheikh.
He has also got
That's
bail
right.
matters.
But on your confession, the stolen articles have been recovered.
But my name also came from the confession of this Shyamlal Mehta.
Counsel for the state is directed to file a counter affidavit in this case. Get the case diary to call for from the concerned court, along with criminal antecedents. Post on 9th April.
Item 3, DA.2194 of 2026.
In this case earlier, first prayer note on 18/9/2024, it was permitted to withdraw, that is Annexure 4, page 26. The second prayer note on renewal after a year, that was rejected by the Honorable Coordinate Bench of this court, page 27. Page 27.
Yes.
Thereafter, note the co-accused has been granted bail by this Honorable Court, Annexure 5, page 29. This is one of the ground note. And second ground note, the date of custody. Third ground note, the three cases have been examined, including the informant. Now, the case note is that prosecution case.
Page 29. Right?
29 is the co-accused.
Co-accused.
Co-accused. That is not on 18th October 2024, after rejection of the order passed by this court. So far, this petition is concerned.
So your rejection order was considered?
That was not, you see, we kindly see.
No, we will not see that. Your rejection order was not placed before the court. Was it placed?
That is not the
नहीं आप अपना कहानी सुनाइए
हम अपना ही सुनाएं, just
मत सुनाइए. Your case has been rejected
Factual
on
event.
merits.
Yes, that is annex page 27. Page 27. Now, Lord, why the petitioner has
What is the
removed the
state?
prayer? Yes. The Stage note I have annexed note 3 witnesses have been examined. The first of all I will permitted to refer to the first information report that starts from page 15. The relevant part note, it is against note 5, 4 accused persons, including the petitioner. Page 19 is the note written report. I am just pressing the relevant part. Page 19.
The case has already been dismissed on
Maybe
merits.
but nothing subsequent steps what has been done. I will just place before Lordship. Not only one line. Page 19, Lordship may kindly see. The husband of this on 6/11/22 को सुबह 6 बजे नेपाल चाय दुकान चाय पीने गए थे उनका हस्बैंड। इसी दौरान पहले से हाथ लगाकर 4 एक्यूज का नाम हुजूर दिए, हम भी उसमें से एक, जिसमें से एक आदमी बेल जिसका हुआ भी उनका नाम है, और नेपाल दुकान के पास गए, हाथ पकड़कर मारपीट करने लगे। इससे बगल में स्थित नेपाल चाय दुकान के घर में घुसते हुए, लेकिन दरवाजा बंद होने के कारण वो नहीं भाग सके। कदीम खान, who has been granted bail, कदीम खान, सद्दाम खान is the petitioner for lordship, and अजरुद्दीन शेख, ये सब अज्ञात व्यक्तियों द्वारा मेरे शोहर सचिन सच को मार दिया गया। हम लोग जब वहाँ पहुँचे, सफेद हुसैन को टेम्पो लेकर इलाज कराने तो क्लिनिक में वहाँ मर। That is the allegation general in nature. Everybody has been alleged to have killed. Now lordship may kindly see the position हुजूर 3 आदमी का हम लगाया है, including the informant. Informant is PW3, that is annexure 3, page 23. Annexure 3, page 23. Lordship may kindly see, she is repeating the same story in paragraph 2 of her deposition. आपके दुकान गए थे, थोड़ी देर बाद जल्दी आओ, अबू को सद्दाम ने गोली मार दी। That is an addition. Then मेरा बेटा राजू ने बताया कि अबू को सद्दाम खान, कदीम खान, अजरुद्दीन खान उन्होंने गोली मारकर मार दिया। सब के ऊपर एलिगेशन। Now my lordship may kindly see the fact remains that जब मेरे पैरा 30 अपने पति के पास पहुंची तो मुझे घटनास्थल ने बताया कि सद्दाम, कदीम और अजरुद्दीन ने गोली मारी। This is उस समय जिंदा थे, तो चारों आदमी का नाम नहीं जो है गोली मार। अब जो देखा जाए किस ग्राउंड पर ऑनरेबल कोऑर्डिनेट बेंच has been pleased to grant bail to. Now lordship will also find these which are not in dispute that on 11/6/2024 charge sheet has been submitted. Then charges have been framed in 2024 and that has been recorded in the meeting order also, and page 29. Earlier also not his player कदीम खान, जिसका प्लेयर हुजूर पैरा 2-3 में लिखा गया है कि DA 15/12/2023 उसका भी खारिज हुआ पहले। Now the player for bail case has been removed on the still that doctor as well as the IO of this case has to be examined. आज भी वही पोजीशन। The male witness is the wife, before whom dying declaration has been given by the deceased, and she has taken the name of Saddam Khan as the person who has fired. This applicant has been assigned the role of instigator. On the above basis, therefore bail has been made, considering such. Now, Lord, I have read the paragraph 30 of the PW3, which he says, who is not the eyewitness, but he says that when she reached there, deceased has disclosed the names of 4 persons who are alleged to have fired. Now, the fact remains not the 2 witnesses, Dr.
सर रिपीट मत करिए, हम आपका हर
are
एक
IO are to be examined still, and he is in custody since not more than a period of about 2 years.
custody since
Date of Yes, 27/2023, more than 3 years. Trial was going on.
कहाँ लिखे हैं 27
Para 30. हमारा हैबिट हो जो पैरा फंड में लिखते हैं, इसीलिए जल्दी नहीं करें। 27/1/23।
27/1/23
जी। तीन ऑर्डर में ही लिखा हुआ है, चार्ज पे हुआ है, 3 गवाही होती है। 11/6/24 को चार्ज पे हुआ। That is page 35.
for the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner has submitted that earlier the bail application of the petitioner was withdrawn. However, later on, in BA number 11008 of 2024, the bail of the petitioner was rejected on merits by order dated 22/9/2025. He submits that the petitioner is in custody since 27/1/2023 and
Child has been criminal on 11/6/24.
still the trial has not concluded and 2 official witnesses are only remaining to be examined.
Yes.
The learned counsel submits that co-accused, namely
Page 29, Kadim Khan.
namely Kadim Khan,
Yes,
who is similarly situated as that of the petitioner, has been enlarged on bail by the coordinate bench of this court. In BA number 6294 of 2024, however, from the order of bail granted to Kadim Khan, it appears that it was submitted that now that the main witness's wife, before whom dying declaration was given by the deceased, and she had taken the name of Saddam Khan, who is the present petitioner before this court. The learned counsel has also submitted that the informant has been examined, who is the wife of the deceased, and she has made general allegation against all the co-accused, and there is no likelihood of conviction of the petitioner. Counsel for the state has opposed a prayer and has submitted that the trial can be expedited. The petitioner has as many as 24 criminal cases against him, and the case of the petitioner was already rejected on merits. The rejection order of the petitioner was not placed before the court by granting bail to the co-accused. After hearing the learned counsel for the parties and considering the fact that the petitioner has 24 criminal antecedents and his bail application was rejected on merits earlier, and only 2 remaining witnesses are to be examined, who are official witnesses, this court is not inclined to enlarge the petitioner on bail. What is the next date in this case? अगला डेट बताइए. अगला डेट उसी दिन आएगा आपका आई को. बताइए ना कौन सा डेट. At this counsel for the petitioner has submitted that the next date in the trial court is on dash. Counsel for the state submits that the state shall ensure production of witnesses. In view of the approached circumstances, this court is not inclined to enlarge the petition on bail. The state is directed to promptly produce the witnesses before the court. The counsel for the state is directed to communicate this order to the superintendent of police of the concerned district and also director prosecution. बताइए next day.
I'll provide the date note.
आप communicate कर देंगे, आज order upload हो जाएगा. ठीक है, जितना कम्युनिकेशन होता है सब अपने रिकॉर्ड में ठीक से रखिएगा, क्योंकि अगर बेल मेरे पास दोबारा आया कि विटनेस से प्रोड्यूस हो रहा है तो यू विल बी एट द डॉक. वी डोंट बॉदर अबाउट इट. आपको डायरेक्शन है, आप कम्युनिकेट करिए.
2 minutes.
Item 4, BA 2195 of 2026.
Earlier, a final is completed under section 365 and 34 of the procedure.
Also, for the state is directed to file a counter affidavit and antecedent report of the petitioner. केस डायरी तो वहीं से आएगा ना, वो जो केस डायरी का ऑर्डर होता है, कॉल फॉर केस डायरी फ्रॉम द कंसर्न को. काउंसिल फॉर द स्टेट इज डायरेक्टेड टू फाइल काउंटर एफिडेविट एंड एंटीसिडेंट रिपोर्ट पोस्ट ऑन 9th of April.
Item 5, BA 2199 of 2026.
In this case, the offence under section 64(2)(m) There is 376 of the IPC note. The lordship may kindly see note as per the FIR. Occurrence took place on 22/11/2025. Alleged that at 8 p.m. the petitioner entered into the house and committed rape and threatened the children of the informant. This is the allegation. Now the FIR was lodged.
What is the stage of the case?
Stage of the case not the after cognizance not it is pending for trial. Now your lordship, further development is that during the pendency of the bail petition and the FIR since lodged not after 2 months of the occurrence, and she is a married lady, and when she was produced before the medical officer, she declined to get herself examined, and therefore not the matter has been settled out of the court note, that is annexed to page 17. Of course, it is not compoundable, but the intention of the government is apparent from page 17. Both the parties have filed a petition that they have already, that has been done not on misconception, and since the FIR note was lodged after 2 months, and when she was directed, the IO produced her before the medical officer, she declined to have examined, medically examined.
कहाँ से पढ़ेंगे? She
She
declined medical examination.
I have stated note, that is note paragraph 11 with reference to the case diary. Case diary में मौजूद है ये बात. Paragraph 10 and 11 of my petition. Paragraph 10 and 11 with reference to the case diary. I can produce not the photocopy, but I will not. You know, see this my.
कहाँ लिखे हैं that she refused medical
Yes,
examination? Can you read that?
Para 12. Although on 12/1/2026, the victim was sent to Southern Hospital Greedy for medical examination.
चार्जशीट हुआ कि नहीं?
चार्जशीट हो गया.
डेट बताइए. आप कस्टडी में कब से?
कस्टडी मुझे 15 से चार्जशीट अभी नहीं पहुंच सका. चार्जशीट हुआ भी 15/1/26 से 15/1/26 3 महीना नहीं है, इसलिए हो सकता है चार्जशीट.
Yes, you are for the informant.
Matter has been compromised. I am certified.
Compoundable है.
नहीं कंपाउंड तो केस खत्म होने के लिए जो लेकिन कॉन्डक्ट अगर अल्टीमेटली ट्रायल भी होगा तो गवाही में क्या
कॉम्प्रोमाइज के बेसिस पे हम आज तक किसी को बेल ले ली.
मेरे कॉम्प्रोमाइज को जो मत
वो भी
देखा
इतना
जाए
सीरियस ऑफेंस.
इसको नहीं देखा जाए, लेकिन कॉन्डक्ट के बारे में बोल रहा हूँ. घटना घटी है 25 से
और the council appearing on behalf of the आपको क्या लगता है? Yes.
As per offense is very serious in nature, your lordship. And why she has lost the case after 2 months? That has been the FIR itself. Her husband was not there.
आज के ज़माने में फोन पे बात भी नहीं होती है क्या? Did she inform her husband?
When his husband come, then she lost the
बेटा को
There was
छुरी के आधार पर इनके साथ रेप किया. And she kept silent for 2 months.
threatening is there, your lordship.
Threatening to the children, and she kept silent for 2 months and refused medical examination also.
Yes, your lordship, that is there.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petition
There are
states that
27 of the
the petition is in
Jharkhand.
custody since 15/1/2026.
That is not
And
actually that.
There is delay of 2 months in filing the FIR. He submits that he has referred to paragraph 12
This is
of the
paragraph
bail
27 of the case.
paragraph 12 of the bail petition to submit that she also refused to get herself medically examined.
That is paragraph 27 of the case.
The learned counsel has also submitted that the petitioner has been falsely implicated in this case. The informant has appeared and submits that he has no objection for grant of bail to the petitioner. The learned counsel for the state has submitted that the case diary is not available with her to verify the statement in paragraph number 12 of the bail application. She has also submitted that delay in filing the FIR is explained by saying that the husband of the victim, had gone to Gujarat,
Mumbai.
had gone to Mumbai to earn a living. After hearing the learned counsel for the parties and considering the fact that there is delay of 2 months in filing the FIR, although there is allegation that the child of the victim was threatened, and as per the statement made in paragraph 12 of the bail application, the victim had also refused to give consent for a medical examination, and further the informant of the case has no objection for grant of bail to the petitioner. The petitioner is आपने अपना वकालतनामा फाइल किया है? The petitioner is directed to be enlarged on bail. However, the learned court, with the condition, the learned court shall verify the statement made in the bail application that
Paragraph 27 of the diary.
just a minute. The learned counsel has submitted that the statement has that this fact would be apparent from paragraph 27 of the case.
Okay, yes.
Yes. The learned court shall verify the statement of the petitioner from the case diary, and if it is found that the victim had consented for medical examination and her medical examination was done, the petitioner shall not be released.
Yes. Yes.
वही से verification यहाँ क्या था?
उसमें लास्ट केस में 28 दिन 2004
कहाँ है अब 28 दिन तो बहुत जल्दी हो गया ना.
नेक्स्ट डेट को 28 के बाद
28 दिन इसमें लिख दीजिएगा.
Item 6, DA.19.03.2026 of 2026.
This is an acquisition program of regular wage. Section 103, the old is 302 IPC. 103. It has been added later on. The originally not the FIR was registered under section 126, subsection 150, subsection 2109, and 3/5, that is not the 34 IPC. Later on, not the 103 has been added. But in this case, we are finding that no research back or CPT was rejected. I have listed for the copy of that order and initial one. There is not the case and counter case, and both the parties had not the having land issue, and the persons of both the parties had sustained injuries. Whereas so far petitioner is concerned, the Kailash Sonka, he is the alleged to have not given one blow. Later on, the deceased petitioner also died in the course of treatment. At that time, at the spot, he had not died. This present petitioner Kailash Sonka was assaulted by the adversary on the neck, and thereafter he had assaulted.
On the same day, in the same
Yes,
incident.
the same annexure 2 lot, delivered the FIR, lodged by from our side. That lot starts from page 20, 3, page 34. And relevant lot is handwritten.
In which the petitioner is the victim.
Yes, the petitioner was also assaulted.
That's right.
This will find from page 29. दोनों तरफ से जो मार हुआ, दोनों तरफ से इंजरी हुआ. पेज 29 जो
ये आपका FIR है, काउंटर FIR.
हमारा FIR है.
और उनका और ये आपने फाइल किया है FIR.
Annexure 3 इसमें Annexure 2 में तो हम एक्टिव हैं.
Annexure 2 में आप एक्टिव हैं. Okay.
और
Annexure
Annexure
3 is the
में-
counter FIR.
Counter FIR.
Relating to the same incident.
Yes, same incident मैडम. अब इसमें Annexure 3 से दिखा रहे हैं पेज 29. जो 4th line from the top दिखाया जाएगा। जो लोग हमारे सर हमारे सभी एसएससी है कि जख्मी कर दिया राकेश महतो पिताश्वर के बाबूलाल महतो फरसा से कैलाश का कि गर्दन पर वार कर जख्मी कर दिया। हम वही कैलाश
Yes, madam, what do you have to say? What do you have to say?
Lordship, there is allegation of assaulting deceased on head by this petitioner, Lordship. And as per the review order, the cause of death is opined as due to head injury and its complications.
There is case and counter case. Both the parties have suffered injuries.
Both the parties have said.
We do not know who assaulted first.
It has come in the FIR that this petitioner, who assaulted first, that is.
We do not know, right? BA number 2206 of 2026. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that there is case and counter case in connection with the incident, and the petitioner himself is a victim of the incident, which is apparent from the counter case. Although, as per the allegation, the victim of the present case has died in the hospital during the course of treatment. The learned counsel for the petitioner has submitted that the learned counsel for the state, while opposing the prayer, has submitted that though there is case and counter case, but due to assault of the petitioner, the victim of the present case has died. However, she is not in a position to dispute that arising out of the same incident, there is a counter case in which the present petitioner is the victim.
और हमारा किसी पहले
कब से आप जेल में हैं?
हम जेल में हैं जो
चार्जशीट हो गया?
हाँ सर
चार्जशीट के बारे में कैसे पता चलेगा?
और भी लोग जो
जी?
और भी लोग एक्यूज जो है ऊपर क्लासेस में बोल गया और ये फैसिलिटी मिल रहा है तो ये का सबसे वाली
Submits that the petition is in custody since 29/1/2026. And has also submitted that it is not clear as to who assaulted first. After hearing the learned counsel for the parties and considering the fact that there is case and counter case, and victim also suffered injury at vital part of the body. Neck injury में है, neck में है,
नेट पर
vital part बोलेंगे.
कोई क्रिमिनल एक्सीडेंट है ये हम रिसॉल्व है और हम लोग पहले किसकी
The petition is directed to be enlarged on date. कोई antecedent नहीं है लिखे?
हाँ जी
Counsel for the petitioner has also submitted that the petitioner has no criminal antecedent.
There are 17
For admission, attempt 7, BA 9791 of 2025, along with attempt 8 to 10.
इनका एक और केस में कौन सा डेट है? इसमें काउंटर फाइल करेंगे आप? साइबर ऑफेंस है?
साइबर ऑफेंस है, केस डायरी आ गया।
केस डायरी आ गया है?
My question is just now I see there are two victims in this case. Number 10.
एक 3 केसेस एक साथ है, ये वही
चार
होता है?
केसेस एक साथ है, 7, 8, 9, 8।
7 to 10.
आप ऐसा करें, ठीक है, एक नोट में पैराग्राफ नंबर सब डाल के किसमें कितने विक्टिम है, कितना अमाउंट इन्वॉल्व है, कौन से पैराग्राफ में आप कर दीजिए. ही सीकिंग टाइम, इसको मंडे करना है.
Then Tuesday.
Tuesday. Counsel for the parties are present. The case diary has already been received. On account of personal difficulty of Mr. Rahul Randall, and at the request of the counsel appearing on behalf of the petitioners, the matter is adjourned and is directed to be posted on Tuesday in the supplementary cause list. In the meantime, the counsel for the state is directed to prepare a short note with regard to the allegation against each petitioner by referring to the case diary and also giving the details of the victims and the amount involved.
During course of argument submit कर दें।
आप कोर्स
चार
फाइल
बना के।
एंटीसीडेंट इनका पता चला?
Incident में या लॉस कोई सारा चीज हम डिटेल बना के देते
They are also directed to inform this court about the criminal antecedent of each of the petitioners. मंगा लीजिए, तो आपको तुरंत मिल जाएगा।
Item 11 BA 12052 of 2025.
Who is for the petitioner? Petitioner absent. Counsel for the state is present. Sorry? क्या बोल रहे हैं? You have got the case diary? Counsel for the state has submitted that. Counter has already been filed. She has received the case diary. She is directed to submit the case diary to the court. Holds this case on Monday.
Item 12 BA 12180 of 2025.
Yes, please. Antecedent बताइए.
एंटीसीडेंट एक केस का कोई एंटीसीडेंट
One case. नहीं तो
इसमें हम उसको फाइल कर देते हैं सब
कोई जरूरत नहीं. देखिए, आपको एनडीपीएस में एंटीसीडेंट वाले को हम बेल नहीं देते हैं. मेरा एकदम स्टैंडर्ड फॉर्मूला है.
वो दिखा देते कि उस केस में भी आई वाज फॉल्सली इंडिकेटेड, उस केस में भी मेरे पास
टोटल करा
अरे उस केस में मेरे पास कोई रिकवरी नहीं.
कोई बात
अरे दो चीजें बोल
नहीं.
एक तो लेडी है, इनके घर पे
लेडी के लिए कोई स्पेशल लॉ
वही बता दे कि इनके घर पे रेप किया गया और इनके पूरे फैमिली मेंबर को एक्यूज बना दिया इंक्लूडिंग हर.
नहीं.
और इसमें जो इसका जो पहले
केस डायरी आया नहीं. देखिए, देने लायक होता है.
समझ गए बट
इसीलिए थोड़ा सा कोऑपरेट करिए.
फाइल कर देते इसको मंडे ट्यूसडे को लेके सप्लीमेंट्री उस केस में डिटेल हम डाल देते
Not required.
कि उस केस में भी मेरे पास
Not required. BA number 12180 of 2020.
विड्रॉ कर.
Counsel for the petitioner seeks permission to withdraw this petition. After some argument, when this court was not inclined to enlarge the petitioner on bail, the counsel for the petitioner seeks permission to withdraw this petition. Withdraw. This is withdrawn.
तो फिर उसको डिस्पोज ही कर दे.
कोई बात.
तो उसको डिस्पोज ही
कोई
कर
फर्क नहीं पड़ा. अब हो गया. नेक्स्ट.
साइन कर दीजिएगा. Item 30 BA 42 of 2026.
पास ओवर आज नहीं हो पाएगा क्योंकि कोई केस हमने फिक्स किया है. कोई बात नहीं. डिसमिस थोड़ी कर रहे. ये साइबर क्राइम है.
साइबर क्राइम.
काउंटर एफिडेविट वही सेम ऑर्डर. काउंटर एफिडेविट कॉल फॉर केस डायरी क्रिमिनल एंटीसीडेंट रिपोर्ट 9th of April.
केस डायरी आ गया.
केस डायरी आ गया. काउंटर फाइल कर रहे हैं आप?
मैं काउंटर फाइल कर रहा हूं. काउंटर फाइल कर देंगे.
कर देंगे. आप कर दीजिए. केस डायरी हमारा वहां से भी आ जाएगा. कोर्ट से भी आ जाएगा. आप अपना अपीयरेंस दे दीजिए.
काउंटर का डायरेक्शन.
हाँ, डायरेक्शन हम कर देंगे. आपको बस यही चीज मेरे कोर्ट में साइबर क्राइम में आप बस यही देखिए. एंटीसीडेंट देखिए, इनके पास से कौन सा सिम और क्या चीज रिकवरी हुआ, विक्टिम का डिटेल्स आपके पास और कितना फ्रॉड.
उसको हम कनेक्ट करते हैं.
बस उतना ही कनेक्ट. बस उतना ही. एक चीज और हम देख रहे हैं कि इन द केस डायरी आई एम सीइंग कि जहाँ जहाँ पर केस इंस्टीट्यूट हुआ है वो लोग इनको रिमांड पर लेना चाहते हैं.
एप्लीकेशन
वो एप्लीकेशन दे रहे हैं, तो उसका क्या हो रहा है?
कुछ का देते हैं, कुछ पे नहीं स्टार्ट
उसमें बेल होने के बाद रिमांड पे चले जाए।
कुछ केस डायरी में
चले ही जाएंगे ना।
वो तो वहाँ जैसे
तो इतने एक सेकेंड रिमांड पे कहाँ कस्टडी पे लेते हैं आप?
जहाँ वो रिमांड
तो
होगा
आप क्या खुद चल के चले जाते हैं वहाँ पर?
नहीं,
फिर
वहाँ वो जेल से निकलते ही समय रिमांड चल जाता है, वहाँ पे पुलिस बुला लिया।
वैसा नहीं,
ऐसा इतना भी एफिशिएंट नहीं है स्टेट।
एक्चुअली स्टेट का जानते हैं, वो रिमांड वो जान के डिस्क्लोज नहीं करते तक, लेकिन कुछ में डिस्क्लोज होता है, वो लोग अपना लगा के रखते हैं। बाहर वाले जो केसेस
वो तो
ऑलरेडी एप्लीकेशन दे के रखते हैं लोग।
लेकिन अगर मान लीजिए वहाँ से रिमांड पे ही आ रहा है तो फिर अगर ये छूट जाएंगे तो बहुत परेशानी में फंस जाएंगे।
दिक्कत यही हो रहा है कि एक ही केस में दो केस हो रहा है, वहाँ भी केस लगा, उसमें पुलिस आता है, यहाँ भी एक केस हो जाएगा।
सब आप लोग सुप्रीम कोर्ट से सारा केस टैग करा लीजिए अपना, यही होगा ना। एक केस में एलिगेशन है यूज का जिसमें विक्टिम भी है, दूसरे केस में विक्टिम ने केस फाइल किया हुआ है, टैग है ना दोनों के लिए अलग अलग सजा तो नहीं होगी ना। फिर तो उसके लिए हम लोग थोड़ी एडवाइस देंगे आपको, आप लोग करिए, आपको जो करना।
आइटम नंबर 12 में मुझे उसमें ऑर्डर पास कर दिया, इसलिए हुजूर का ऑर्डर हो जाता है ना, तो ट्रायल
नहीं कोई बात नहीं, ऑर्डर हो चुका है।
नहीं, हुजूर का ऑर्डर कहें कि ट्रायल कंक्लूड हो जाता है, इसलिए कह रहे हैं क्योंकि हुजूर का ऑर्डर हो जाने से जैसे उसमें जो रिजेक्ट होता है तो उसमें एसपी को डायरेक्शन हो जाता है कि वो टाइम से ट्रायल को कंक्लूड करवा दिया जाता है। इसलिए हमारा नंबर रिक्वेस्ट है व्हाट्सएप पे उसको उसमें ऑर्डर पास कर दिया जाता है जिससे ट्रायल कंक्लूड हो जाए।
तो विड्रॉ का प्रेयर क्यों किया? असाइन नहीं करिएगा ना, मत करिए, ये सब वीडियो रिकॉर्डेड है, आप चिंता ही नहीं करिए, हमको कोई दिक्कत नहीं है, आप नहीं भी साइन करिएगा तो काफी है।
नहीं साइन की बात नहीं हुजूर,
फिर क्या बात?
हुजूर का जो जैसे ऑर्डर जो पास
आप जब प्रेयर किए विड्रॉ करना चाहते हैं तो फिर क्या हो?
हुजूर का जैसे ऑर्डर पास हो जाने से तो वो ट्रायल विदिन समय से कंक्लूड हो जाता है, क्योंकि ऑब्वियसली जितना भी हुजूर का ऑर्डर होता है इस केस में तो उसमें जो विटनेसेस जो है अपना एसपी लोग जो है कि खुद से
कोई जरूरी नहीं है कि हम आपके केस में भी यही ऑर्डर करें।
नहीं हुजूर का ऑर्डर
लाई फाइल दीजिए, कहाँ है ऑपोजिट पार्टी का है, लेके आइए उनको, ऐसे हम ऑर्डर मॉडिफाई या रिकॉल नहीं करते हैं, बुलाइए और आपने जो आर्गुइंग काउंसिल है उनको भी बुला के लेके आइए, ऐसे नहीं होगा, मजाक है क्या? नहीं आप उनको बुला के लेके आइए, मिस्टर नीलेश कुमार आर्गुइंग काउंसिल को बुला के लेके आइए, अदर साइड को बुला के लेके आइए, तभी हम मेरिट पे डिस्कस करेंगे, ठीक है? आप उनको लेके आइए ना, आप ही के सीनियर है ना, अब भाग तो नहीं गए होंगे ना कोर्ट से, वो अदर साइड को भी बुला के लाइए, इत्मीनान से हम रिजेक्ट कर देंगे, हमको कोई चिंता नहीं, इत्मीनान से रिजेक्ट कर देंगे। एंटीसीडेंट है ही, एनडीपीएस में एंटीसीडेंट है तो क्या ही दिक्कत, रिजेक्शन
नहीं कोई दिक्कत नहीं, लेकिन हुजूर का ऑर्डर से कब जो है कि
क्योंकि मेरा समय मत वेस्ट करिए, आपको बोले आर्गुइंग काउंसिल को लेके आइए, अदर साइड को लेके आइए, हम आपका करेंगे।
आइटम 14
और नहीं लाइएगा और नहीं भी ऑर्डर करिएगा ना, साइन नहीं करिएगा तो हम हमेशा याद रखेंगे और आपका कभी भी विड्रॉ करने का परमिशन नहीं देंगे, नेवर।
Item 14 BA 68
Counsel
of
for the
2026.
petition seeks permission to withdraw this bail application. This petition is dismissed as withdrawn.
Sign कर दीजिए। Item 15 BA 217 of 2026.
Yes.
Curiosity Office 296 corresponding to 366 years. When he is in custody for about more than 14 months.
कब से?
10/1/2025. In this case, after framing of charge, the victim as well as the informant who is none other
Age कितना है?
16 years. 16 years है और informant they are the vital witnesses in this incident case who have been examined as PW 1 and 2. Wherein she has in fact not alleged anything wrong against this petitioner. I have annexed the copy. It appears from page 18 onwards. The relevant is at page 19. May I read this?
ट्रायल का क्या स्टेज?
वही तो दो विटनेसेस हो गए हैं
आउट
out of 4 और लास्ट विटनेसेस जो हुए हैं वो अगस्त 2025
अभी कराते हैं आपका सारा बिजनेस का एग्जामिनेशन.
and after that there is no
All the witnesses will be examined. करेंगे ना आप एग्जामिनेशन? कौन बचे हैं? खाली ऑफिशियल विटनेस बचा होगा?
ये उसके बाद मैंने 4 में तो 2 यही मैटर हैं लेकिन ये दोनों जो है इनफैक्ट नथिंग हैज बीन रेज्ड अगेंस्ट मी.
हम ट्रायल तो नहीं कर रहे ना. आपका एक्सपीडाइट करा देते हैं. सीरियस ऑफेंस है.
एक बार अगर मुझे खाली डिपोजिशन को देख लिया
डिपोजिशन पढ़ के हम कुछ भी प्रोनाउंस करना उचित नहीं है. ट्रायल को इफेक्ट होगा.
and I am in custody for about 9 days.
I take care of that. नेक्स्ट डेट बताइए कब है?
नेक्स्ट डेट
हाँ बताइए ना.
नेक्स्ट डेट ये आपको अगस्त ये सॉरी अक्टूबर 2025 में.
आपको पता ही नहीं है अगली तारीख कब.
उसके बाद का इधर अभी इनिशिएट किए गए
पता रहेगा तो उनको डायरेक्शन देंगे ना उस दिन विटनेस प्रोड्यूस करने के लिए.
ऐसा
बताइए. पता करके बता सकते हैं.
आई विल ट्राई.
कोई बात नहीं. चल कोई बात नहीं. खाली ऑफिशियल विटनेस रह जाएंगे. PA number 217 of 2026. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the out of 4 witnesses, only 2 witnesses has been examined so far, which is apparent from paragraph number 24 of the bail application. He submits that they have not fully supported the prosecution case. Counsel for the state has opposed the plea. He has also submitted that the petitioner is in custody since 10/1/2025, having no criminal antecedent. The learned counsel for the state has opposed the plea and has submitted that the allegations are serious and he is not aware as to what transpired after 25/9/2025, which reveals that 2 witnesses were examined till 25/9/25. After hearing the learned counsel for the parties and considering the seriousness of offence, this court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. Counsel for the state is directed to communicate this order to the Director of Prosecution and also to the Superintendent of Police of the concerned district to ensure justice.
Some time may be fixed if possible, because he is in custody for about 14 months. And even
सजा हो जाएगी तो कितनी सजा होगी? सजा होगी तो कितनी सजा होगी?
इसमें मैक्सिमम है 10 years. मैक्सिमम 10 years.
आप वेट करिए, आप प्रोड्यूस कर दीजिए. I'll tell you one thing. In all the cases where I am directing about production of witnesses, there is a direction of the court. And if they do not produce, bail to accused तो होगा ही, लेकिन SP will be at the dock. Because I am asking him to ensure production of witnesses. He has to furnish possible and acceptable explanation for non-production of witnesses. ये दोनों नहीं चल सकता है कि witness से produce करेंगे और आदमी जेल में जाएगा. These two things cannot go simultaneously.
Yes.
These two things cannot go simultaneously. नहीं handle कर सकते हैं तो FIR मत lodge करिए, कुछ मत करिए.
तो उसी के खाली हम
इसीलिए टाइम फ्रेम नहीं देंगे. अगर कुछ डेट्स में 1-2 डेट में विटनेस नहीं आते हैं तो यू फाइल फ्रेश. We'll see that. ठीक है. और सेम डे तो आई थिंक कम्युनिकेट हो जा रहा है. हमको लगता है नेक्स्ट डे तक ऑर्डर कम्युनिकेट हो जाएगा.
Item 16, DA.501/2026.
Yes.
Matter relates to 103 of BNS matters, a case of murder. And according to the allegation, it is alleged by the informant, who happens to be the uncle of this petitioner, that on the relevant day,
Yes, आया हुआ. Yes.
Case 13.
You read the FIR. Are you named in the FIR? Are you named in the FIR?
Yes,
पढ़िए please.
all three persons, mother, father, and this petitioner.
Please read the FIR.
Page 30. निवेदन पूर्वक कहना है कि मैं अली मियाँ पिता रसूल मियाँ सचिन मेरा पुत्र कादिर 27/2/25 को सुबह लगभग 6:30 बजे मुखिया जी से मिलने के लिए जा रहा था तो ग्राम तोमर निवासी मोहम्मद मासूम जिस पिटिशनर अपने घर के पास रोक लिया और अचानक मेरे पुत्र को 5-6 लाठी से माथा पे वार कर दिया और गिर गया। गिरने के बाद मोहम्मद इस्लाम अंसारी the father of this petitioner and Muhammad Islam Ansari with the Sachin sir, Muhammad Masoom, this petitioner, then Sajda Khatun, she is the mother of this petitioner, तीनों बेरहमी से पिटाई कर दिया जिससे माथा हाथ उंगली व कमर में काफी गंभीर चोट आई। घायल अवस्था में ग्रामीण के सहयोग से इलाज हेतु सामुदायिक स्वास्थ्य केंद्र बोला। वहाँ पर जवाब देने पर रामगढ़ ले गए, सदर अस्पताल रामगढ़ ले गए, वहाँ भी डॉक्टर साहब जवाब देने के बाद मेदांता अस्पताल रांची ले गए, वहाँ पर भी जवाब देने के बाद रांची रिम्स रेफर कर दिया। वर्तमान समय में इलाजरत है। आपसे प्रार्थना है सचिन सर। Initially the fire was lodged under section 109, then a moment he died minus 103 and 8 minutes. This is the allegation. Informant is not the eyewitness and the allegations are as against all three, and mother and father have been granted, and both are the agnates murdered and land dispute is going on. It has come in the entire case diary, and informant is not the eyewitness. Since 28/2/2025 is in custody, having no criminal records.
27?
28 to 2025. And an extra.
Yes, what do you have to say? You are for the informant?
Yes, I am from the informant. He is the main accused, Your Lordship. One of the co-accused charge sheet have not been submitted against one of the co-accused, and the father.
Charge sheet has not been submitted
against one of the co-accused.
Okay, that's
Who
right.
is lady mother, and father is only supporting there. The main accused is this person. He hit in the head of the.
Is there any eyewitness to the occurrence? Because the informant is not the eyewitness. Is there any eyewitness?
I have annexed the cognizance order also. The cognizance has taken as against all.
आप उनको बोलने दीजिए please. हाँ बताइए. Is there any eyewitness to the occurrence?
Eyewitness.
Where is the state? Yes, state. BA number 501 of 2026. Heard the learned counsel appearing on behalf of the parties. The counsel for the petitioner submits that the petitioner is in custody since 28 April 2025. He has further submitted that though there is direct allegation against the petitioner in the FIR, but the informant is not the eyewitness of the occurrence. He has also submitted that the two co-accused, that is father and mother of the petitioner, has been enlarged on bail. The learned counsel has further submitted that the victim was taken to the hospital. The FIR was registered primarily under section 109 and subsequently upon death in the hospital charge under section 103 of BNS has been paid. The counsel for the state is absent. The informant of the case is present. Are you Agnes?
Yes.
During the course of hearing, the counsel for the informant has not disputed that parties are agnates and there is land dispute between the parties. And also the fact that the informant is not the eyewitness to the case. To the query put by this court, the ये केस डायरी देखिए, eyewitness दिखाइए, उनको दिखाइए केस डायरी. State का है नहीं यहाँ. I could not find any. Considering the fact that the co-accused has been granted bail and there is land dispute between the parties and the parties are agnates and the informant is not the eyewitness to the occurrence, the petitioner is directed to be enlarged. Sorry?
My submission will be recorded.
What?
This petitioner hit in the head of the
Eyewitness to कोई नहीं.
FIR.
The case diary has been handed over during the course of hearing. The case diary has been handed over to the learned counsel for the informant. He has not been able to point out any eyewitness to the occurrence from the case diary. However, he has submitted that the petitioner is the main assailant and the victim has died due to head injury.
Item 17, DA.579 of 2026.
Yes.
Last occasion after hearing the matter, the Honorable was pleased to call for a report from the trial court.
Yes.
And to know the what section cognizance has been given. Meanwhile, the case has also filed complaint.
Okay, cognizance under section 108.
Yes.
What is this 108?
Attempt abetment to suicide.
Abetment.
So initially FIR was under section 103. It was.
Who are you?
No, I am the husband.
Only one witness has been examined out of it.
Yes, ma'am. And charge has been made on 23/7/25 and I am in custody since 8/11/24.
It is direct allegation against him. Not against him.
One thing. If you not will see.
When was this marriage organized? Date of marriage?
Specific date of marriage has not been pointed out.
You are not aware when did you get married?
On that score I do not have instruction also.
What do you mean you don't have instruction? Date of marriage is extremely important. When the wife dies, date of marriage is extremely important.
There are two children. It is beyond 7 years. It is beyond 7 years.
How do you say?
Because for the reason that the section 304B has not been added because if had it been a case of death within 7 years, it was default that the case was.
What is the corresponding section of 304B under the new act? I'm still working on the corresponding sections. Please let me know.
It is 106.
Sorry?
106. 80 of BNS. Doubted. 80 of BNS is corresponding section for 304. So marriage was not.
Read the FIR.
Yes. Page 18 is FIR.
Read it please.
सबने निवेदन पूर्वक कहना है कि मैं पति रहा है 60 वर्ष 50 वर्ष होता खाता कहाँ पंचायत समिति थाना करनाडी ओपी कुकड़ा जिला गिरिडीह का स्थानीय निवासी मेरी बेटी अश्विनी देवी की शादी धंडी के रहने वाले दिनेश पिटिशनर रति राय पे स्थान रति राय जिला गिरिडीह के साथ हुआ था जिससे एक लड़का एक लड़की है शादी के बाद में दिनेश राय पिता का मारपीट करता था। इसके संबंध में गाँव में कई बार कंप्लेंट की गई। पिछले 8 महीने पहले मेरी बेटी के साथ दिनेश राय मारपीट किया था। उसके बाद मेरी बेटी अश्विनी देवी अपने गाँव छात्रावास पूरा पंचायत से आ गई, जहाँ मुझे तो बताई कि राजेश राय अदर पसंद राजेश राय पिता धनेश्वर राय ग्राम सोनपुर जिला गिरिडीह के रहने वाला गलत संबंध बनाने के लिए बोल रहा था, जिसके बारे में पता चलने पर मेरे दामाद दिनेश राय मारपीट कर घर से भागा था। उसके बाद कुछ दिन बाद मेरे गांव छात्रावास टोला में मेरे दामाद का परिवार वाला साथ
For the learned counsel appearing on behalf of the parties, the learned counsel for the petition submits that the petitioner is in custody since 23/7.
8/11/2024.
I will not grant. 8/11 custody since
8/11/2024.
8/11/2024.
The reason because that has been mentioned in the FIR itself. Husband came to know about
The learned counsel submits that the petitioner is the husband, and from the perusal of FIR itself, it appears that 1/3 person was insisting upon the victim to have illicit relationship with him. And ultimately the charge has been framed under section 108.
108.
Yes, suicide. The learned counsel for the state has opposed the prayer and has submitted that the victim was assaulted repeatedly by the petitioner. And ultimately she committed suicide.
There is no antenatal injury in the finger on the body, but it has come in postmortem. It's a single injury.
Suicide में कहाँ से होगा?
पहले से मारपीट का एलिगेशन आ रहा है. Has there been assault?
There is direct, this court finds that there is direct allegation against the petitioner, who is the husband. Accordingly, this court is not inclined to enlarge the petitioner on bail.
Item 18, DA 734 of 2026.
My lordship, I pray for 1 week's time in this.
For what? Why do you need time?
The council appearing for this case has come to dialogue on an emergency matter. Please make
Counsel for the petitioner seeks adjournment. Nobody appears on behalf of the state. Counsel for the state is directed to file counter affidavit in this case, along with criminal antecedent report. Office is directed to call for case study. When should I post it? 9th April?
Yes.
Post on 9th April. Since the counsel for the state is absent, let a copy of this order be forwarded to the Office of Learned Advocate General to ensure compliance.
Item 19, DA.12.43 of 2026.
We can't have Passover today. Same order. Okay? We are asking the state to file counter affidavit. Your antecedent report and the case study is concerned. 9th April. खत्म हो गया? हाँ. आप इतना दुखी परेशान क्यों हैं?
क्योंकि हुजूर का जैसे ऑर्डर जब होता है तो ट्रायल कंट्रोल होता है,
हो जाता है?
हाँ
हमको तो अभी तक नहीं, अभी तो हम थोड़ा ही दिन से
नहीं, हम
ऑर्डर
लोग इससे हम देखे और भी केसेस में क्योंकि हमारा पहले भी एक ऑर्डर हुआ है यहाँ से, तो विद इन टाइम जो है ऐसे वेट नहीं करना पड़ता, नहीं तो 4 फिल्म हो गया उसके बाद से वापस आता है नहीं आता है, लेकिन ये दोबारा फाइल करने का जरूरत नहीं पड़ा।
तो अच्छी बात है, आपने अच्छी
ये
बात
हाँ ये कि अगर ऑर्डर पास हो जाता है तो उसमें
देखिए काउंसिल को परेशान हमको देखने में अच्छा नहीं लगता,
क्योंकि आप लोग लास्ट टाइम में
अगर आपको अदरवाइज कोई परेशानी
नहीं कोई आता नहीं, हुजूर का ऑर्डर मतलब एटलीस्ट
और आपको इतना चीज बता दे रहे हैं, इन केस कोई आपको कोई कॉन्फ्रंट करे कि आप ऐसा क्यों किए, ऐसा क्यों हुआ, दिस इज ऑल अवेलेबल ऑन यूट्यूब, आपके प्रोटेक्शन के लिए। You saying this is for your protection. What you have argued in the court, what happened in the court, everything is available. आपको कोई चिंता की बात ही नहीं है। You were doing the best to the litigant, isn't it?
वाली भी कसम से पहले केस मेरा यहाँ से डिस्मिस हुआ था, लेकिन उसमें जो था कि 12 तारीख को डेट पड़ा था, उसमें विटनेस आ गया
ना, बस ठीक है, आपको यही चाहिए ना, एक्सपीडिशियस ट्रायल, हम सबको वही चाहिए।
अगर महीना 2 महीना में ट्रायल कंक्लूड हो जाता है, ये हम लोग
चलिए अच्छी बात, ठीक है, साइन कर देंगे आप अपने केस पे। साइन हम लोग कराते हैं अपने रिकॉर्ड के लिए कि कल को कोई ये नहीं बोले कि हम तो बोले ही नहीं थे, कुछ ऑर्डर हो गया ऐसा। दैट इज राइट।
Out of 10 detention case, item 45, WPS 7038 of 2017.
I seek your permission to allow the council to appear to DC.
Who is it paid?
Council Mr. Adil Misra.
Yes, Mr. Mishra, can you hear me?
Yes, please.
This was down in the list. I have not gone through the brief, so you have to apprise me about the facts of the case also.
Surely, my lord, sir. I'll try my best.
With this permission, may I just mention?
Yes.
In the mentioning, I had mentioned that I would just point out that these writ petitions have become infructuous.
What is that?
Now, that issue is actually, correct me if I am wrong, Mr. Mishra will correct me. He has challenged the amendment of the bylaws of the trade union by which the management here, the Tata Motors have provided that workers of, am I not audible?
Yes.
That the workers of Tata Driveline Limited can also be members of the trade union. Now, I had raised, if your lordship will see the order sheet, some preliminary objection as to the maintainability of the writ petition. But we need not go into those questions because what has happened during pendency of the writ petition, this Tata Driveline Limited has merged with Tata Motors. So the very objection that those workers cannot be permitted to be a member of Tata Motors Union finishes because the two companies have joined together and all the workers automatically become.
That's right.
So the challenge to the bylaws loses any significance.
Yes, Mr. Mishra, is that correct?
Now, I will just show their own pleading.
Just, it's enough, you don't need to show. Let me just find it out. If it finishes over here, the matter ends.
No, because they have replied to this in the counter.
Just, yes, Mr.
Now, my lords, what my learned friend says, my lords, the rate has not been infructuous. Though the new entities have come in of Tata Motors. But my question goes to the root of my learned friend's client, the TML drive line's existence, that whether TML drive line can take or poach the workers of telco union, because it was for a different company, it was established for a different company to cater to the workers of TML Driveline, but it subsequently by illegal amendments started poaching up the workers of Tata Motors. So my question is that once if my lords are with me on my argument, then the entire existence of TML Driveline and the workers goes away. So that is my submission.
Just a moment. This is Telco Workers Union.
Yes.
TML Driveline is another workers union.
Yes, Milos. If my learned friend will let me present my case, Milos,
Just
I
a
am more
moment.
happy.
Let me be very clear on these facts.
Yes.
TML Driveline
Yes.
is another company.
TML Driveline was another company.
Okay, and
For-
Tata
for
Motors
which-
is another company. Now there was an amendment in the
Constitution
of TML Driveline.
Workers Union saying that they can take the workers as their member of Tata Motors Limited. We are challenging that amendment.
And what has subsequently happened?
Subsequent
TML Driveline has now merged with Tata Motors.
with Tata Motors.
So the natural question is whether the employees of TML Driveline will automatically get the status of employees of Tata Motors.
Yes, I
Will
have
they
no
get
problem
it?
with the employees of TML Driveline.
Right. Now they get the status of employees of Tata Motors. And once they get the status of employees of Tata Motors, so by default, are they entitled to become the members of Telco Workers Union?
Yes, I am for telco workers.
Are the employees of TML Driveline by virtue of becoming the member, by virtue of becoming the employee of Tata Motors, by default, are entitled to be members of your union?
Yes. Yes.
Okay.
And as per the judgment of the Supreme Court also, they will be my members.
Okay. So, what is your grievance over here? You are challenging, what are you challenging in this?
I am challenging the amendment laws in TML Driveline's constitution that they can take the workers of Tata Motors as their member.
Now, when TML Driveline itself has become non-existent.
Yes, that's my entire case. That their worker, the TML, when the company goes, the workers' union also will go.
Okay. And this workers' union of TML Driveline, they have undertaken the amendment after the merger or before the merger?
Even before merger.
Or so far as the amendment is concerned, it is after merger or before merger?
Milos, it is before merger.
Before merger.
Please.
So if there is a amendment before merger, then under such circumstances, after the amendment, if there is a merger with Tata Motors, then under such circumstances, what would be the consequence on this amendment? That is a different cause of action altogether.
What happens? There have been 2-3 amendments. Only to give them a legality, Milos, they kept on amending their constitution. First, they amended their constitution to say that apart from TML Driveline workers, they will also offer membership to the Tata Motors workers. Then what happens? Then second amendment, they change their name.
So primarily there is a dispute between two unions.
Two unions.
One of them is the petitioner union and the other one is TM Driveline Union. They are respondent number?
8.
No, 8 is Tata Motors.
Yes, 5. I'm so sorry.
Respondent number 5.
5.
Right. So now this TML Driveline Workers Union, which was existing prior to merger, they have amended their constitution in such a manner that the employees of your union can also become member of their union.
Please.
Is there any legal bar?
Yes, please. Yes.
A person, an employee cannot be a member of two unions in the same company?
No, my lords, they can't be of two unions. Also, my lords, for a company, for a workers' union to take the workers of another union, my lords, it needs to have certain number of persons in their union to allow. When you have 0 number of workers of that factory or company or industry, then you can't just say that I will start poaching now. This is basically poaching of the worker, which is prohibited under the constitution and trade union.
Okay. Now we'll come to that later. That intricacies will be on the merits of the case. The learned senior advocate who is appearing for, I think, private respondent number 5. You are appearing for 8. Okay. Who is appearing for 5? 8 and 5 maybe. They are maybe in the same boat. He has raised an objection that you have an alternative remedy. Do you really have an alternative remedy?
No, because I don't have an alternative remedy because I have challenged the action of the state, the government, labor department to approve those amendments which are against the statute.
So, under which provision they have an alternative remedy?
Lordship will just confuse the issue. He is Telco Workers Union. If your Lordship will see the earlier orders, I have raised the objection that when he filed this writ petition, his union had been disregarded and cancelled, derecognized.
Derecognized.
And he concealed this fact and filed this writ petition. Now, I am not going into that issue. That is substantiated by my counter also with the orders of the competent authority, which he concealed. What I am saying is his sole objection was that there is this company, TML Driveline Workers Limited, a company, limited. And here is Tata Motors Limited, another company. Now what Tata Motors did was it amended its bylaws, union bylaws, saying that workers of Tata Motor Driveline Limited can also be members here. Now this is what his grievance was, that this should not be permitted, there are two different entities, they can't join, they can't do this. That would have been valid, your Lordship would have heard the legality on merits. But what has happened in between is that this Tata TML Driveline Limited company, lock, stock and barrel, has merged with Tata Motors. So automatically, all the employees of TML Workers Limited become employees of Tata Motors Limited. So what is the significance of this rule now? This rule becomes redundant.
You see, in a company, is there any legal bar from having two workers union?
No, there is no question of two workers. There is no question of two workers union because this TML Workers Union becomes redundant.
TML Driveline Limited
that
had a workers
merged.
union, right? Had a workers union. Now that company has merged with Tata Motors. Tata Motors was already having a workers union. Right? So I want to know what is the provision that by default they will have to go and take a membership of the union. But do they become a member by default?
Yes, by virtue of being an employee of Tata Motors now, they become a member of the union.
You have to-
Because so far as the TML,
I have doubts on this. I think they
Because-
have to go and take a membership of the
Yeah.
union.
that was the clause. They were already coming in here. They were already coming. Now
They-
what has happened
when
is
two
this.
companies are being merged, merger of company does not amount to merger of the
Trade union.
trade unions also.
Your lordship is absolutely correct. But the effect is that the second trade union loses its identity because there are no workers left there in that company. That trade union was of the workers union limited. There are no employees left there.
No, merger does not mean that the, you see, when two companies are merging, maybe that the name of Tata Motors is retained for both the companies.
No, the employees become employees of Tata Motors. That's the principle of merger. They lose their identity. Now, once they lose their identity, there is no workers left in the TML Workers Limited. That union becomes defunct.
Is there any provision to that effect?
And by amendment, this TML Workers Union was de-recognized or surrenders. So
They surrendered their
Because
certificate.
there is no
of
worker left there.
Did they formally surrender it?
Milords, then the existence is over. Then
Yes.
he doesn't have a case at all. Then
TML worker does not need to be surrendered because all the workers have abandoned that and now become employees of Tata Motors.
No, it's
So-
not a case of abandonment. It's a case of two companies taking a call that they have merged.
Your Lordship, I stand corrected, that's there. I missed out. TML Workers Union changed its name to Tata Motors Workers Union. First thing. They merged. And on merger, it became TML Workers Union. So there was a natural death of the first company along with the union. And their challenge that the TML union cannot provide for joining of the employees becomes infructuous because there are no employees left.
It's not so straightforward.
You
Let
got
me
to-
hear it.
Or,
You have heard his objections?
no, there's a reply to
because
the
I've
counter.
heard his objections.
Now let me hear. If
Your Lordship, I just placed the counter affidavit and his reply. He has accepted this position.
I don't even know what is the prayer made in the writ petition
Your Lordship,
because
will
he
just-
has not yet placed the writ petition. Let him place the writ petition. Let me see.
Not in my case, I don't know why my learned friend.
You place your case, please.
Yes, Milords. If Milords will see my Lord's own order of 18/6/2024 in this case. Milords, things will be a bit clear because Milords had summarized the point
Yes.
in my Lord's order.
Can you read it?
Has my Lord got that?
Yes, can you place this?
Yes. Learned counsel for the parties are present. Learned counsel for the petitioner has submitted that the impugned orders have been challenged on the ground that the additional registrar trade union Jharkhand had allowed amendments in the constitution of TML Driveline Workers Union by enabling the members of Telco Workers Union to be members of the same. He submits that such amendment has the effect of changing the constitution of the trade union and therefore such amendment could not have been allowed. The learned counsel for the petitioner has relied upon the judgment passed by this court in LPTA number so and so. He has also relied upon order passed by this court on 8 August 2023 in so and so case and has relied upon para 6 thereof. He has further relied upon a judgment passed by the Honorable Supreme Court reported in 2017, Escorts Employees Union versus State of Haryana. Learned counsel for the respondent seek adjournment by stating there have been subsequent developments during the pendency of this case and they need to file counter affidavit before this court. And the directed instructions to file counter affidavit. Now, Milords, this is my Lord's own order. Now, Milords, Thereafter, my lords, this matter was for quite some time argued before court number 14, my lords, where my learned friend, I don't know what is his position today, because he is appearing for the company, and the company should be per juem plea, my lords, a non-partisan. But here, my learned friend seems to be supporting respondent number 5, I don't know why.
It doesn't make any difference. We go by the records. We don't worry.
Yes. So
He is a senior counsel appearing for one of the respondents, so he will have a right
yes,
of audience.
but also, my lords, have to keep in mind that Trade Union Act says that the company should not be biased towards one worker union because it goes against the welfare of the workers.
You see, the senior counsel appearing has got such an aura that he has practically, he has overtaken the counsel appearing on behalf of the trade union. So the counsel of the trade union is practically assisting him in the court. Correct?
Then, my lords, I am more than happy, my lords, if they are on his shoulders. Then I am more than happy. My lords, then, my lords, if my lords will see order dated, my lords, I'll just come. Then, my lords, it was argued for some quite time before court number 14, and my lords, that where my learned friend had taken an objection, I'll be very fair, my lords, that I am in the meanwhile, I am a deregistered workers union. So therefore, I don't have any right to file writ petition before this order, because I don't have any legal entity. So I had answered it before the court number 14, my lords, and in continuation of that, if my lords will see the order answer. If my learned friend could help me with that. Yes, my lords, on 13/10/2025, if my lords will see the order dated 13 October.
I'm there now. I'm on that order.
Yes, may I read it? At the outset,
I've read
senior
it. I've read it. I was reading it for quite some time.
yes. So, and thereafter, my lords, this case was again heard, and then, my lords, I had, my lords, argued for some time on the maintainability of the writ petition. Then, my lords, this matter was part heard before him, as far as I know. Now, my lords, since it is before my lords, and my learned friend is not, my lords, I don't know whether he stands on his maintainability question.
I do stand. I said
There is so much of contest on maintainability.
There is in the very beginning, but I said that's not the matter. It can be disposed of as infructuous on this ground. So we need not waste the time of the court.
Yes. So if my lords want, I will start again on the maintainability, or I will.
You have filed a specific petition on the point of maintainability? Which is that you have filed an IA or you have taken it in the counter?
No, that I have taken in mind. But it also will come on this infructuous. This is specifically pleaded and their acceptance is there. It also will just come to the counter.
See, they are not accepting it.
The counter is there. Their reply is there. They can't run away from that. The lordship will come to my counter of respondent number 8. Has my lord got it?
Yes.
Paragraph 22 straight away.
Counter of respondent number. Sorry.
8.
respondent number 5 can have. Yes, respondent number.
You also will straight away come to page 13, paragraph 22.
Yes.
And basically, that it is important to mention that there was a merger of TML Driveline Limited company with Tata Motors Limited, while order dated 5/4/2018, passed by the Honorable National Company Law Tribunal, Mumbai. And this was made effective from 1/5/2018. Therefore, there is no company existing in the name of TML Driveline Limited, as the same has been merged with Tata Motors Limited. That 23. The TML Driveline Workers Union, your Lordship's question, got name amended to TML and Driveline Workers Union, registration number 211, while order dated 17/10/2016, passed by Additional Registrar Jharkhand, and further amended to Tata Motor Worker Union, registration number 211, while order dated so and so, passed by the Additional Registrar Trade Union. Therefore, your Lordship's question was very pertinent. What happens to Workers Union, TML Workers Union? It ceases. It changes its name and ultimately merges as Tata Motors Workers Union. That it is stated that in the entire matter, petitioner union is not a beneficiary or a sufferer in any manner whatsoever, as the said trade union is still deregistered and derecognized in the state of operation being Jharkhand. That with the merger of TML Driveline Limited with Tata Motors Limited, present respondent, the name change and the name change of TML and Driveline Worker Union to Tata Motors Union, the writ and the prayer made therein has become infructuous and will not be prudent to pursue the writ petition, and any interference will result in disturbing industrial peace and harmony. This, now your Lordship will come to the reply.
Now with the same name, there are two unions.
No.
As by virtue of this, they change the name to Tata Motors Workers Union. There is already a Tata Motors.
No, there is not. That is telco workers.
Telco workers.
May I say something, my Lordship?
And so far as telco workers union is, that I have raised earlier, and I will point out if necessary, that stands deregistered, derecognized. They concealed this and filed the writ petition. Now if your Lordship comes to their rejoinder, reply to the counter.
You see, what do you mean by this?
Yeah.
And will not be prudent to pursue the writ petition, and any interference will result into disturbing industrial peace and harmony, which is there for last many years, where Tata Motors Worker Union is espousing the cause of the workmen peacefully. What does that mean?
Now, your Lordship had seen that in the beginning there were two separate companies,
Yes.
TML Driveline Limited and Tata Motors Limited. The two companies have joined. Similarly, TML Driveline Union has merged with Tata Motor Union and changed its name to Tata Motor Union. Therefore, there is only one union left. So, one company and one union left.
So the other union, which was already existing, that is Telco Workers Union.
That's a separate entity.
So that has ceased to exist.
No, that is there. That has ceased to exist because the Registrar Trade Union has cancelled their registration. Now, just let me complete this. Enough confusion is there already. Now, if your Lordship will just come to the reply.
Let him come.
Just if your Lordship will come to their reply to these contentions. that is titled Rejoinder on behalf of petitioner to the counter affidavit filed by respondent number 5 and 8.
Yes. The state whose order is under challenge, have they filed any counter?
Yes.
You have filed your counter?
Yes.
Now, if your lordship will come
From
to para
1
69.
to 4, respondent number 1 to 4, my lords, they have filed the counter affidavit, my lords.
Para 69 of the
Para, your lordship, exactly, page 100, para 69.
Para 69. Yes.
Page 100. That in para 22, the respondent company has raised the most crucial fact necessary for determination of this case. The company asserts that TML Driveline Limited, for which the respondent union was registered as evidenced by Lecture 1 of Writ Petition Form 8, merged into Tata Motor Limited by order of NCLT Mumbai dated so and so. We concur with this fact.
Merger is admitted.
Under clause 10 of the scheme of merger agreement accompanying merger order, it is clear that no individual remains an employee of TML Driveline Limited. All former employees of TML Driveline Limited are now employees of Tata Motor Limited. What more remains? Their own admission.
If my learned friend is now over, then I can, because I am very thankful to my learned friend that he has shared some of my labor to Milos assist in this court.
Yes, please.
Please, now Milos, if Lord will speak, my Lord has already seen order dated 13/10 of this court.
Yes.
Then my Lord's order dated 14/10/2025. I did not got that.
Yes, please.
Heard in part, list this case, so and so. And then, my lords, it was next listed on 31st October 2025, where my learned friend's objections were answered. I'm reading it, my lords. Heard learned counsel for the petitioner at length, apart from his contention regarding the maintainability of the writ application, he has also argued that even if the petitioner union is held to be deregistered, it would still have locus standi to represent the cause of the workers. He further relied upon the decisions passed in Akhil Bharatiya Shoshic Karmachari Sangh. He further submits that the writ is also otherwise maintainable because the petitioner union is not having any alternate remedy due to paucity of time. Further arguments on behalf of the petitioner list this case on. And thereafter, lords, it is listed before my lord. Please, lords. Now, my lords, I would be very happy to assist my lord in person if my lords could note down certain important dates.
Yes.
One, Milos, my petitioner union, the petitioners, is Telco Workers Union, and it was registered, it was working since 1946. When the company's name was Telco. Then second important point, Milos, is the respondent number 5, TML Drive Lines Limited, was established or registered in 2014. Now, if Lord will see the bylaws of this union when it was established. In the Miller's writ petition paper book,
Page number?
Page number, Miller's, I'm very sorry, my page numbers are very sketchy. If it is at 23, annexure 2. Annexure 2 of the writ petition.
Yes.
Please let me look at that. So, Milos, the name of the union, item 1, the TML Drive Lines Workers Union. And then the objectives at item 4. Objectives of the union are, this is the constitution, TML Drive Lines Limited टेल्को जमशेदपुर जिला पूर्वी सिंहभूम झारखंड में काम करने वाले कर्मचारियों को संगठित करना। So it was limited to this.
Yes.
Now, Millers, second important date is 29/8/2016 at page 35 of the writ petition paper. As my lord WhatsApp. This is 29/8/2016. Now this is the first amendment. This is the impugnated amendment I am challenging, where very conveniently
I'm not able to get it from this that Sansodhit Niyamavali. This is the
Yes.
amendment.
Yes, yes.
This is amended rules.
Yes, rules and bylaws.
Under challenge.
Yes.
Page 35.
Is that. Now the name of the union, the item 1 Millers, now we'll see very cleverly, it changed from TML Drive Lines to TML and Drive Lines.
TM Driveline and Messrs Tata Motors Limited.
Yes.
4A.
Because it is TML and Driveline Workers Union.
No, it is Messrs TML Driveline Limited and Messrs Tata Motors Limited.
Yes, because that is at item 4.
Yes.
I am showing item 1 at
Okay,
the top
name.
of the page. First, the change of name,
Yes.
TML and drive lines. The Lords will recall
Yes, I've seen them. I've
that
seen
in
them.
so it is now TML separate and drive lines separate.
And clause 4A extends to both the company.
Yes, now clause 4 is where the entire thing, the surreptitious getting into the other unions workers, is that now the objective will be TML Drive Lines Limited and Tata Motors Limited. So it changes its own constitution for which it was registered में काम करने वाले कर्मचारियों को संगठित करना.
तो दूसरे के घर में घुस गए.
Yes, I am obliged, my lords.
आजकल क्रिमिनल केसेस देख रहे हैं तो दूसरे के घर में घुसने का ज्यादा ध्यान है.
Because it happens everywhere. Because, just on a side lighter note, even geopolitically, my lords, these days everyone is getting into others' home.
I can't comment. And let me not comment.
Then, my lords, at next page on the same document,
yes, please.
at item 6, my lords,
Yes.
साधारण सदस्य मेसर्स TML ड्राइव लाइन्स लिमिटेड एवं मेसर्स टाटा मोटर्स लिमिटेड में नियोजित 18 वर्षीय उससे अधिक उम्र का कर्मचारी संघ के साधारण सदस्य के रूप में प्रवेश करने का पात्र होगा, बशर्ते वह संघ द्वारा बनाई गई समय समय पर बनाई जाने वाली नियमावली और उपयुक्त विधियों का पालन करने में सहमत. So they will take the workers of Tata Motors Limited as their own workers, however, for which purpose they were not registered under the treaty, despite of that. Now, my lords, on this amendment, the petitioner filed an objection. My secretary, the petitioner union secretary, through whom this writ petition has been filed, also filed a separate objection, and some others filed objections, which my lord will find at page 47, annexure 4. I'm for now skipping it, my lords, just. Then annexure 5 is at page 48.
Yes.
Is the order of the government labor commissioner, where it says that the objections have been received in regard to the amendment, and in the last 4 lines, if I may read the original words, that जमशेदपुर तथा श्री अभय कुमार सिंह एवं अन्य द्वारा प्रेषित पत्रांक 0 दिनांक 23/8/2016 की छाया प्रति एवं उसके साथ संलग्न अनुलग्नकों की छाया प्रति संलग्न करते हुए निर्देश दिया जाता है कि उभय पक्षों के साथ उक्त विषय पर सुनवाई कर तथा श्रमिक संघ अधिनियम 1926 के प्रावधानिक व्यवस्था के अंतर्गत समीक्षा कर अपना सुस्पष्ट प्रतिवेदन भेजने का कष्ट करें। प्रतिवेदन में यह स्पष्ट अनुशंसा करें कि श्रमिक संघ अधिनियम 1926 मतलब दिस इज इम्पोर्टेंट के प्रावधानिक व्यवस्था के अंतर्गत उक्त संविधान को संशोधित किया जाता है अथवा नहीं जा सकता है अथवा नहीं। So there was a clear direction by Labour Commissioner that please see if this amendment is valid under the Trade Union Act or not.
Yes. Then what happened?
Yes, because then Miller's, there is a Miller's annexure 6, page 49. Where the sub-registrar, Deputy Labour Commissioner Jamshedpur hears the parties in which Abhay Kumar Singh was heard. It doesn't seem that Prakash Singh or Telco Workers Union's representatives were heard from the letter, and at the end, without giving any kind of reason under Trade Union Act, merely on the fact that this amendment was passed by majority or the quorum in its GBM, General Body Meeting. Therefore, I am approving this amendment.
This annexure 5, by which the commissioner had, Labour Commissioner had directed the Deputy Commissioner to decide whether it is valid or not. It is
Yes.
not addressed to you. Copy also not marked to you.
No, because copy was also not marked.
Annexure 5, can you have a look at
Yes.
annexure 5?
Yes, I'm obliged, Lord, when the copy was not.
Copy is not marked, but this has been done pursuant to the objection filed by the petitioner. Copy
Yes.
not marked.
Yes.
And annexure 6 is the order.
Order.
Does
Deputy
it
Commissioner.
reflect participation of the petitioner?
Abhay Kumar Singh.
Abhay Kumar Singh is the representative whose
Of the
representation
petitioner.
of the petitioner.
Abhay Kumar Singh is representing
Of the petitioner.
the petitioner. So he had participated.
Plus, I don't have instructions that he is my representative. My instruction says Prakash Singh or
his name
my learned friend will.
His name appears again and again.
He had his time in the morning, in the evening. He will have his time after I finish.
This particular order is referring to the objection filed by Abhay Kumar Singh.
Yes.
Right, referring to the objection. But is there any hearing on this?
This is a matter of inquiry. So you have to inquire and he has reported that these are the objections, these are the replies, this is how it happened, this is why I allowed.
So the objection which was filed before the Labour Commissioner was entertained by the Labour Commissioner, and inquiry was to be conducted by the Deputy Labour Commissioner, and he submitted a report or he submitted an order.
Your Lordship, Your Lordship will see the bottom of page annexure 5. It has been marked to Abhay Kumar Singh. Pratilipi is there to Abhay Kumar Singh.
Mahamantri. Abhay Kumar Singh. That's right. Alright. Now this order, this is an inquiry report or this is
Inquiry report.
Report. Okay. Then this is under challenge.
No.
And thus at the bottom of this order of Deputy Commissioner, page 53, he sums up without giving any reasoning, saying उपरोक्त जांच प्रतिवेदन से स्पष्ट होता है कि संविधान संशोधन हेतु आवेदन श्रमिक संघ अधिनियम तथा टीएमएल ड्राइवलाइन वर्कर्स यूनियन जमशेदपुर के निबंधित संविधान में निहित प्रावधानों के तहत श्रमिक संघ अधिनियम 1926 की सेक्शन 28(3) के तहत विहित समय सीमा के अंतर्गत दाखिल किया गया है। एतेम संशोधन।
I just want to know from you, this particular inquiry does not deal with your objection.
I'm sorry, Milors. I'm so sorry.
This particular inquiry does not deal with your objections, the points that you have raised, at least in the finding. There is no finding with respect to the objection which has been raised by you.
By me.
Now
Yes.
let us have a look at the objection which you had specifically raised, that is at annexure 4 and 5 perhaps.
Yes.
4 and 5.
I'm much obliged. Annexure 4.
Yes, that is the objection that you had raised.
Is by Prakash Kumar.
Okay, where is your objection? It's the same thing, it's a union representing, isn't it?
Yes. So, because my objections even on the first paragraph, मैं प्रकाश कुमार टेल्को वर्कर्स महामंत्री टेल्को वर्कर्स यूनियन निबंधन स्वयंसेवक का निर्वाचित महामंत्री हूँ। मैं टीएमएल ड्राइवलाइन वर्कर्स यूनियन द्वारा बुलाए गए आम सभा में के प्रस्तावित प्रस्ताव पर कठोर आपत्ति दर्ज कराते हुए यह कहना चाहता हूँ कि गत दिनांक 16/8/2016 को टीएमएल ड्राइवलाइन वर्कर्स यूनियन द्वारा एक आम सभा बुलाई गई, जिससे यह प्रस्ताव लाया गया कि टीएमएल ड्राइवलाइन वर्कर्स यूनियन का नाम बदलकर टीएमएल एंड ड्राइवलाइन वर्कर्स यूनियन रखा जाएगा। टीएमएल ड्राइवलाइन वर्कर्स यूनियन श्रमिक संघ अधिनियम के तहत निबंधित यूनियन है, जिससे निबंधन संख्या है टीएमएल ड्राइवलाइन वर्कर्स यूनियन श्रमिक संघ अधिनियम के अध्याय 3 के सेक्शन 25(2) का उल्लंघन कर अपने आम सभा में नाम बदलने का असंवैधानिक प्रस्ताव पारित किया गया है। श्रमिक संघ अधिनियम 1926 के अध्याय 3 के 25(2) से यह स्पष्ट किया गया है कि यूनियन अपना नाम दूसरे निबंधित यूनियन के समरूप नहीं रख सकता है। आम सभा के बाद अखबार में आए बयानों से यह स्पष्ट होता है कि टीएमएल ड्राइवलाइन वर्कर्स यूनियन श्रमिक संघ अधिनियम 1926 के अध्याय 24(2) का भी उल्लंघन करते हुए असंवैधानिक रूप से टेल्को वर्कर्स यूनियन के सदस्यों के सम्मान और उनका अधिकार छीनना चाहती है। मैं अपने आपत्ति के साथ अखबारों की प्रति भी संबंधन कर रहा हूँ। टीएमएल ड्राइवलाइन वर्कर्स यूनियन का गठन टीएमएल ड्राइवलाइंस के कर्मचारियों द्वारा किया गया था, लेकिन अखबार के माध्यम से मजदूरों में साजिश के तहत यह भ्रम फैलाया जा रहा है कि टाटा मोटर्स के मजदूरों द्वारा माननीय उच्च न्यायालय रांची के आदेश पर दिनांक 20/8/2015 को डीसी एवं एसएसपी जमशेदपुर के पूर्ण देखरेख एवं नियंत्रण में कराए गए चुनाव के उपरांत श्रमिक संघ अधिनियम 1926 के अंतर्गत निबंधित टेल्को वर्कर्स यूनियन के अधिकार का अतिक्रमण करते हुए टीएमएल ड्राइवलाइंस वर्कर्स यूनियन असंवैधानिक तरीके से काबिज होना चाहती है। It wants to encroach. अतः श्रीमान से अनुरोध है कि टीएमएल ड्राइवलाइन वर्कर्स यूनियन के आम सभा द्वारा पारित इस असंवैधानिक प्रस्ताव का तत्काल कार्यवाही करते हुए निरस्त करने की कृपा करें। इस न्यायपूर्ण कार्य के लिए मैं आपका धन्यवाद। And this objection, my lords,
this objection has not been dealt with in the inquiry.
no, not at all. Not even the passing off in the name. Under 25(3), that is also not there.
So what ultimately happened after this report?
After this report, my lords, after approval, then, my lords, Annexure 7, the sub-registrar of trade union, who is empowered and is the party here, in the light of the report of the deputy commissioner and his approval, the amendment was accepted and accordingly the name and the objectives were changed.
What all annexures are under challenge?
Milos, that the Milos under challenge, if Milord will see my prayers, my prayer, Milords, in the beginning of the writ petition, page 1,
Annexure 8.
Immediately after the index, the synopsis.
That's it. Annexure 8. Annexure 7
Annexure 7.
and Annexure 8. Both.
Yes.
So, apart from saying that your objection has not been taken care of, what
Yes.
other thing do you have to say?
Second, Milords, the amendment is not fulfilling the conditions of the Trade Union Act. That's second.
You see, if your objection has not been taken care of by the authority while dealing with your objection,
Yes.
then why should the writ court enter into the merits?
Yes,
Do you
exactly.
say that it is a matter of remand to the authority for fresh consideration of your objection, or you want something else?
Milords, at this point of time, a remand, Milords, I'll take instructions on that.
You
I'm
don't
not
need to
saying
say
anything.
take instructions. You are a senior counsel. You just tell us.
No, I'm
The
not a
points-
senior designated.
No, but I treat you as senior only, so that doesn't make any difference.
Milords,
What
that's
I'm indicating is that if in the impugned order some point has not been taken care of,
yes.
and the order is impugned in a writ court is not an appellate court. In an appeal, the points can be re-agitated and taken into consideration, but for a writ court,
Please, Milords.
if any point, a crucial point has not been taken into consideration, should the writ court decide the case on merits, or it should be remanded on this point, that your objection has not been taken care of?
Yes, Milords, that is apparent, as Milords had pointed out.
Subject to what the other side has to say, they have lot of objections with regard to the writ petition. I think that should be sufficient.
Milords, that's one. But at this point, as an officer of this court, was that at this point, Milord's remand will not, serve purpose, because there has been, after this, there has been another amendment.
That is also under challenge in this writ petition.
Yes, Milord.
In this particular writ petition.
Yes.
Where is that order? So you have challenged it by way of amendment.
Yes, by way of amendment.
Where is your IA? That has been allowed?
Milord, no amendment has not been allowed. It was in fact once Milord's dismissed as in default, and then it was restored.
So why are we hearing this case for 1.5 hours? If any amendment is there in the writ petition which has not yet been allowed, then under such circumstances, what can we do about it?
Yes.
This is something which you should have pointed out at the threshold.
Yes, I
From
had.
quarter to 12, I am hearing this matter, and still there is an amendment yet to be allowed.
Please, Milord, I accept my mistake. I should have pointed in the beginning. But however, my learned friend brought in so many issues that Milord, I could not. Milord, this IA is there.
Can you get the IA number? I don't have the IA.
Where is the IA number?
IA number is Milord 7574 of 2018.
I don't have it on the card.
Is there any IA pending?
Two IA.
7574 is it pending? He says that it has been restored.
Yes, Milord, it was, the entire writ petition was restored.
एक IA pending है restoration of IA.
Restoration of
11397 of 2025. This IA was restoration of
restoration of 11397.
11397. Pending.
Your petition seeking amendment was IA number?
757 petition seeking amendment is IA number 7574 of 2018.
Record would show that probably this disposed of long back.
This was disposed of on 28/7/2022, and in this the writ petition was dismissed for non-prosecution, and IA was closed at the time of dismissal of the writ petition for non-prosecution. There is nothing, IA dismissed nothing, because when once a writ goes, the IA also goes. Now this writ petition has been restored.
I don't know, we have not been served with the IA.
7/5. But somebody had represented you. You were all appearing.
11/9.
Now
11/9/2018. This IA is mentioned.
You have got the order of 28th of July 2022.
We are looking from your Lordship's website that it stands.
IA number, this writ petition was dismissed for non-prosecution. 2 IAs were closed. One was 1361 of 2018 and other was IA number 7574 of 2018 were closed.
Yes.
Thereafter, it is mentioned as closed.
were separate orders passed or as a
It is
consequence of
as a consequence of the dismissal of the writ petition. Once
Yes.
first it is dismissed for non-prosecution writ petition and pending IAs, these two IAs stands closed. Right? Now the writ petition has been restored.
the IAs were not restored.
It is not, we are not being so technical about it.
Then if Milord will have order dated 11/9/2018.
11/9, that is prior to 28th of July. 11/9/2018.
No, because I am saying because this IA was served to others, even the government council, respond number 5 was given time to file reply.
Respondent number 5 was given time to file a reply.
Yes.
And the order was passed in your presence. You are representing respondent number?
8.
8. Respondent number 8 was also represented.
Yes, I have seen the order.
Yes.
So VP Singh.
Yes.
And respondent number 5 was Indrajit Sinha.
Yes.
Probably once it was dismissed
Yes.
on the records. Because the records which I got,
You see, your juniors should have assisted you with the records. What is there in the records?
even they don't have it.
But we have it, no? We have it. We are hearing it for such a long time. And it's a complete waste now.
This is the first time he is mentioned about amendment. He's not
I don't know,
mentioned it
first time,
earlier.
second time.
None of the earlier arguments he has ever mentioned that there is subsequent amendment.
And what is that amendment? IA number निकालिए.
By this amendment, they changed their name entirely to Tata Motors Workers.
So even if they change the name to Tata Motors Workers Union, so your objection with respect to the initiation of amendment, right? That has not been taken care of in the impugned order.
That has not been taken care of.
So it is just a formal change of name only, which is the subsequent amendment which is under challenge. But so your basic objection with regard to expanding the scope of this particular union to another industry, that has not been taken care of.
Has not been taken care of. Has not been, in fact, gone into.
And what is the date of merger?
Because date of merger, Milos.
वो निकालिए आइए निकालिए
16/9/2016.
Yes, 16/9/2016.
Para 22 of the counter affidavit.
This is the date of merger. And what is the date of impugned order? It's 4/10/2016. Annexure 6 is 4/10/2016 and it is certainly much after that. So the order on your objection was passed without taking note of the fact that there was a merger.
Yes.
Right? That is also a very glaring fact. What is the consequence of merger? And what is the nature of objection that he has raised? These things have not been considered by the authority.
They have been considered.
Show us that merger has also been considered. Because this merger, the fact about merger was never brought to the notice of the authority who has passed the impugned order.
You want to just come to section 26 of the trade union.
No, we'll come to the section. We'll see the impugned order first. Two things what I am observing. One is the kind of objection they had taken that has not been addressed.
Now,
They could have rejected it. There is no problem about it.
It has been considered and rejected.
We'll see that.
And
We'll
it's a
see that.
six.
Second, the consequence of merger has also not been taken care of. The amended bylaws has been ultimately finalized later on. So even this merger has a bearing in the matter, isn't it? Merger, even according to you.
It doesn't. I'll just come. The application for change was made before merger.
That's right.
And that is what has been allowed. My submission is that subsequently, when the company is amalgamated, there was a further amendment where the name also changed, only one company and one union was left. Now, if one company and one union is left, how can anybody object to that? Your Lordship, it's like this.
One company and two union with the same name.
No, only one union is left.
This is petitioner is Telco Workers Union.
Your Lordship, Telco Workers Union is something foreign to the entire thing. His registration, if Your Lordship comes, cancelled, it's a non-entity.
When was it cancelled?
That is
2017.
what I said.
May 2017. Much after the amendment.
No, just a minute. 8th of July. Your Lordship, the writ petition, kindly note the date.
Now, Mr. Mishra, you just hold on for a while because this is something which we need to figure out.
The writ petition was filed on the 5th of December 2017. The Lordship has got the date?
Yes.
The cancellation of the registration of the union and derecognition date is 3/5/2017. So 6 months prior to the filing of writ petition, their registration was cancelled by the registrar trade union partner. They concealed this fact, and Your Lordship knows, once the registration is cancelled, then it is not a legal entity. Concealed this fact.
Where is this order of cancellation?
Cancellation, Your Lordship, counter affidavit, annexure A at page 90.
This counter affidavit of respondent number 8. Counter affidavit of respondent number 8 doesn't have page 90. 19.
Your Lordship.
Page number 34 of our article.
नहीं अभी दो जगह से मत एक ही डॉक्यूमेंट.
Same order.
नहीं. Yes. पढ़ी?
Adesh. Please say.
Page 19.
At 20.
Next, at 20. Yes.
What is at 20? Shramik Sangh Adhiniam, so and so. चूंकि टाटा लोकोमोटिव एंड इंजीनियरिंग
This is for non-filing of returns.
They have been putting not non-filing of returns. Your Lordship will
Return
recall
jama nahi.
that is one of the things. I'll just explain to you. Now Your Lordship will remember earlier their Labour Commissioner used to sit at Patna, and therefore their registration was at Patna. As a consequence of bifurcation, they ought to have moved to Jharkhand, applied for registration here, because they had no territory left in Bihar where they were working at a factory. Labour Commissioner noticed them. They did not appear, they did not file any return. They abandoned Patna totally. Newspaper publications were done, they didn't appear. Newspaper publications were there giving a list of about 200 trade unions, that these trade unions are operating in Jharkhand, so kindly get yourself registered there, you are being delisted here. They did not respond. Accordingly, their registration was cancelled. They ceased to have a legal entity. 7 months before the writ petition was filed. And they come and file, concealing all these facts. They file the writ petition here.
Was their registration ever restored in Jharkhand?
No. They did not even apply in Jharkhand. Even today, they have not applied in Jharkhand. And the registration number which they are now quoting is given to someone else in Bihar.
Naturally. Somebody
So someone else has got that
वो
registration
नंबर आप
number.
छोड़ देते तो दूसरे को मिलता है ऐसे ही
और बिहार यहाँ झारखंड में they have not applied. We took this objection. Then subsequently in 23 or 24, they approached this court. This court dismissed it. They went in LPA. It was dismissed. They went to Supreme Court. It was dismissed.
So in the writ petition, there was a direction that they may approach the registrar trade union of Jharkhand. So writ was not exactly dismissed, right? Some window was given to them.
Yes.
And then maybe they filed appeal against that.
The fact remains that the trade union which comes before your lordship ceases to be a legal entity. Your lordship will come
though representation was filed on 23/7/18, yet no decision was taken. Right? To take a final decision within two months. That was the order before the appellate court. LPA.
Your lordship.
LP order.
Your lordship. That LPA order was challenged by them in Supreme Court.
That's right.
Supreme Court
But the
dismissed.
order is, it was not a dismissal of it.
No. But where is the registration?
That's right. We will find it out from them. Then this SLP was dismissed. Where is the order of dismissal? This one.
SLP, your lordship will get at page 29 of counter affidavit of respondent number 8.
Yes. Then Telco Workers Union filed another writ petition at Patna.
And on 14/7/23,
on 14/7/23, the case was admitted at Patna.
admitted,
And prima facie appears that the order is without jurisdiction. This was the interim order. And there shall be interim stay of the interim order. So consequences what?
consequences, your lordship knows, the Supreme Court has settled that the registration does not revive.
No. That is something else. The Supreme Court has not pronounced that the registration exists or it does not exist.
No. What I am saying is consequence of stay
Yes.
subsequently granted does not undo whatever. It's only ultimately when your lordship allows the writ petition that those orders are set aside. But otherwise the cancellation order operates. In 23, he gets a stay after we objected before this court. So his writ petition was not maintainable the day he filed.
take care of it.
Your Lordship, once the registration has been cancelled by the Registrar Trade Union, the opinion विधि विभाग से परामर्श लिया
हम
गया था।
opinion नहीं देखते किसी,
विधि
जो
विभाग
चीज
से
रिकॉर्ड में
परामर्श-
नहीं है उसके बारे में।
वो रिकॉर्ड में है।
विधि विभाग का ओपिनियन भी आप रिकॉर्ड में लगा दिए। हाँ?
थर्ड पैराग्राफ में योर लॉर्डशिप ये मेंशन विधि विभाग के परामर्श से देन वो उसके ओपिनियन के बाद री रजिस्ट्रेशन के लिए पब्लिकेशन पेपर पब्लिकेशन निकला था।
I'm sorry, Milords.
And there was no re-registration.
I'm sorry, Milords. If someone else is arguing, then I'll.
Who are you?
Is appearing in serial number 44 and 46. We are appearing in serial number 44. Counsel Mr. Anil Mishra.
Your stay from Patna High Court in any case would revive his registration for Patna, not for Jharkhand.
You see, the registration was for undivided state of Bihar.
But then that after bifurcation, that is why they were asked, go to Jharkhand and get a registration because this is all not legal. You have no workplace in Patna. Now, on basis of that illegal registration, even if they have a registration, they can't come here and maintain a petition.
We'll deal with that also. This is the objection on the point of maintenance.
Maintainability.
That's right.
That the day they filed the registration, their writ petition, their registration had been cancelled. There was no stay by any court. They concealed this fact that my registration is cancelled. And therefore, having concealed material facts, your Lordship will not grant them any indulgence.
That's right.
If my learned friend is.
Just a
And
moment.
now-
Just a moment.
Yes, yes.
Please.
I'll wait.
The trade union participated before NCLT also? Must have.
Must have.
Represented, who represented the workmen? Who represented the workmen before NCLT? Must be reflecting from the order itself. Normally, all the creditors and list is always there in the scheme of merger.
At page 84 is employees and employees.
Now, if your Lordship will just come back to the consideration by the Commissioner, your Lordship said that they were not heard.
Let me just have a look at that. No,
page
I
6.
did not say they were not heard. There was no hearing. Let us take it.
There was hearing.
Before the inquiry, at the stage of
Yes,
inquiry.
yes.
That is Annexure 7.
Annexure 6. Annexure 7 is the report.
Annexure
6 at page 49.
No, that is a communication. That is not.
No. That is the inquiry report. Annexure 6
Yes, Annexure 6.
is the inquiry report.
Yes.
Harold has got it. Page 49.
कागजात प्रस्तुत.
So, number 1. शिकायतकर्ता श्री अभय कुमार सिंह गुट के भव्य को समर्पित दिनांक 7 को के पत्र के पहले पैरा में उन्होंने स्वीकार किया है कि श्रमिक संघ अधिनियम 7 के तहत कानूनी रूप से जांच उपरांत 2 यूनियन HB एक्सेल कर्मचारी यूनियन एंड 7 कर्मचारी यूनियन के विलीन की स्वीकृति देते हुए विलय के उपरांत नए यूनियन DM 7 वर्कर्स यूनियन दिनांक इतने को स्वीकृति प्रदान की थी और दिनांक इतने को इस यूनियन का निबंधन किया गया, जिसका निबंधन संख्या ये है। इसी के समर्थन में श्री RK सिंह गुट, दैट इज द ऑपोजिट पार्टीज होते हैं, के द्वारा कहा गया कि श्रमिक संघ अधिनियम 2026 के नियत प्रावधानों के तहत विलयीकरण के पश्चात उप श्रमिक जमशेदपुर एवं 7 रांची द्वारा व्यापक जांचों दौरान TML ड्राइव वर्कर्स यूनियन को निबंधित किया गया तथा कार्यकारिणी समिति के सदस्य एवं पदधारकों का नाम फॉर्म B रजिस्टर में दर्ज किया गया। उक्त निबंधन सम्मति के अनुसार उसकी अवधि 3 वर्ष की है, अर्थात 12/1/2017। आम सभा की दिनांक 16 की बैठक में जिसमें शिकायतकर्ता श्री सत्येंद्र कुमार सिंह एवं राजेश पटेल भी शामिल थे, ने भी अपना हस्ताक्षर करके पारित प्रस्ताव पर अपनी सहमति प्रदान की थी। आम सभा के बाद कार्यकारिणी की प्रथम बैठक दिनांक इतने को में भी शिकायतकर्ता श्री सत्येंद्र कुमार सिंह एवं श्री राजेश पटेल उपस्थित होकर अपना हस्ताक्षर किया था। श्री RK सिंह गुट के अनुलग्न 2 शिकायतकर्ता अभय कुमार सिंह दिनांक इतने को की आम सभा में उपस्थित नहीं थे, क्योंकि वे HB एक्सेल कर्मचारी यूनियन एवं HBP ट्रांसमिशन कर्मचारी यूनियन में से किसी भी यूनियन के सदस्य नहीं थे। शिकायतकर्ता श्री अभय कुमार सिंह गुट के भव्य को समर्पित दिनांक 16 के पत्र के दूसरे पैरा में इनकी शिकायत है कि इस नए यूनियन का निबंधन के बाद लगभग 2 वर्ष तक उसके पदाधिकारी ने यूनियन को बिल्कुल मृत्युप्राय कर दिया। न तो मजदूर के लिए कोई आवाज उठाई गई, न मजदूरों से संबंधित किसी समस्या पर प्रबंधन ने वार्ता की। इसके जवाब में श्री RK सिंह गुट के द्वारा प्रमाण स्वरूप कागज समर्पित करते हुए कहा गया है कि विलय के उपरांत एवं निबंधन के पश्चात यूनियन के द्वारा मासिक चंदा जो 1600 these are the things they have done. So it's wrong to say that he was not heard. Every objection was considered. Number 4, श्रम आयुक्त निबंधन 16 कार्यालय से वार्षिक विवरणी भी वर्ष 16 के लिए दाखिल की गई। उपरोक्त तथ्यों के से यह प्रमाणित नहीं हो पाता है कि नए यूनियन के निबंधन के बाद लगभग 2 वर्ष तक इसके पदाधिकारी ने यूनियन को बिल्कुल 16 कर दिया। 3, शिकायतकर्ता श्री अभय कुमार सिंह गुट के भव्य के समर्पित दिनांक 16 के पत्र के दूसरे पैरा में उनकी यह भी शिकायत है कि कार्यकारिणी के पदाधिकारी के निबंधन के बाद संविधान के अनुरूप सही तरीके से चुनाव अपेक्षित था, जो नहीं किया गया। इस संबंध में 16 now it is about elections he raises. Then he goes on, then para 4 if you lordship will come, शिकायतकर्ता अभय कुमार सिंह के गुट से 16 ने उनकी शिकायत का 16 किया। This is what. Then 6 again the same thing, both the contentions are raised, and then he comes to a finding that there is no substance in these contentions. And now where is the objections specifically that this you could not have amended, this you could not have amended? Those objections
State, you are there. State. What is your response to Annexure 4? Was this objection received by you? Because this objection does not find place in the discussion. Annexure 4. which is dated 16/9/2016, there is no discussion of this objection in the impugned order.
Yes, my lords. My lords asking me.
Now I am asking the state.
Oh,
They must have responded to it that this was filed, not filed. The objection dated 16/9/2016. No, that is okay. That he has already taken care of your standing. That he was deregistered. I want to know Annexure 4, has it been taken note of? How do you respond to Annexure 4? This particular report or adjudication, whatever be it, is not referring to Annexure 4 at all. Am I correct? Annexure 4 is a different, the objection under Annexure 4 has a different tenor altogether. The allegation in Annexure 4 is totally different from what has been dealt with.
That is for the petitioner to bring on record what happened.
No,
He is not saying that I was not heard.
No. Annexure 4 is there.
That's a direction to the Labour Commissioner.
No, Annexure 4 is not a direction to the Labour Commissioner. Annexure 4 is the
Submitted representation to respond number 2.
yes, by referring that श्रमिक संघ 1926 के अध्याय 3.25.2 से स्पष्ट है कि यूनियन अपना नाम दूसरे निबंधित यूनियन के सम्मुख नहीं रख सकता है, अपना आम सभा में नाम बदलने का असंवैधानिक प्रस्ताव पारित किया। This is what they allege. And
now if your lordship will come to paragraph 15,
okay.
Repetition. This that he is saying that it was not considered not their duty for submission. Paragraph 14 is referring to Annexure 4. And here he clearly says in paragraph 15, last line, however, the objection submitted by petitioner was not referred to respond number 3. So if it was not referred, why will respond number 3 speak about it?
Yes, so I am asking respondent number 3.
It was not referred to respondent number 3.
Yes.
So
the objection was not referred to respondent number 3.
So they have to make a grievance. They have not made a grievance of that. Where is the grievance? There is no grievance against that.
How do you say? What do you say to this para 15?
You wrote on the lighter side, I may just say, Dunya Bibi Razi kya karega kazi? Now Workers Union and Workers Limited and Tata Motors, they decide to join hands. The two unions amalgamate.
Because may I answer to this lighter note? Yes. Because Constitution doesn't permit this, because welfare of then the management and the worker union will collude between themselves and play with the welfare of the worker by giving less salary, less settlements, less bonus.
Legal status after his registration is cancelled.
यहाँ पे नियम में
registered issue that it says that union is only one which is registered.
This stands admitted. And the order also does not reflect consideration of this objection.
The case is that maritime medicine may come, sir.
Yes.
So you say that the repetition being WPN number such as tried by
The counter affidavit of respondent number 2 and 3.
4 also.
Which counter affidavit are you referring to? I have a counter affidavit of respondent number 2 and 3. There is a separate counter affidavit of respondent number 4.
1, 2, 3 and 4.
6 and 24.
No, I have counter affidavit filed on 22nd of March 2018.
No, this is the
your main counter affidavit, which is to the main writ petition. Counter affidavit on behalf of respondent number 2 and 3 filed on 22nd of March 2018. And this was not filed. इसको छोड़ दें. Struck off from the records.
Direction by the Honorable Court, 20th of July 24.
Specific counter affidavit with regard to what?
Legal.
With regard to? Whatever it is. Just what do you have to say in response to it?
Milos, if I may be permitted, because the issue regarding non-hearing is my learned friend, I don't know, all over the place.
No,
if
it is not a
Milos
matter of hearing.
will come to one annexure, this will clear all the doubts that we will not heard. Because it is my duty to show. I'll show
No,
it.
you have not raised a grievance that you have not heard. Have you raised a grievance in the writ petition that no hearing was given to you?
Yes, yes.
Which paragraph is that?
Because may I
Your
show the
appearance is
annexure and
recorded.
thereafter I'll show the pleading below? If Milords will
Which is that annexure?
yes, please Milords. Milords will see at page, because this is the proceedings of the Labour Department before passing the order. Milords, it is at page 69, annexure 9 of the writ petition paper. Can you got that? It starts from page 69, 69.
Yes, 69.
Yes. Now this is the Milos, I believe, proceedings, the recording of proceedings by the Labour Commissioner. And if Milords will...
No, inquiry report is by the Deputy Labour Commissioner.
Yes,
Where
yes.
you were heard, and this is the proceeding of the Commissioner.
Yes, Milords. Now...
So that is a different stage altogether.
No. If Milords will come to page 80 now, 80, directly.
Yes.
80, item 5, clause 5. May I read it? इसके अतिरिक्त अपने जवाब में श्री अभय कुमार सिंह द्वारा उल्लेख किया गया है कि टेल्को वर्कर्स यूनियन द्वारा भी इस संबंध में श्रमायुक्त को आपत्ति जताई गई है। इस संबंध में अधो हस्ताक्षरी का मत है कि प्रासंगिक जांच डीएमएल गाइडलाइन वर्कर्स यूनियन जमशेदपुर के निबंधित संविधान में संशोधन पर मात्र श्री अभय कुमार सिंह गुट के द्वारा किए गए आपत्तियों तक ही सीमित है, इसलिए अन्य पक्षों के मत इस स्तर पर विचार। Now this is Millard's Adho Hapstachri, be Millard's our Sachin. The signatures are of, and then sub-registrar has also signed. These are all notices of the proceedings. Now coming to my pleadings, Millards.
Yes.
Yes. At page 12, 12, para 23. Onwards. And may not got that 23. That it is stated and submitted that the impugned order could not have been passed without inviting objections from petitioner's union, as it is sole representative or purpose of Tata Motors. That it is stated and submitted that official respondents have violated the principle of natural justice in not considering the objections filed by the petitioners. That it is stated and submitted that the rejection of petitioner's objection is an eyewash, as it is clear from the record that it was not considered at all by allowing amendments in the bylaws of respondent trade union. So there is sufficient pleading in this regard. Please.
What do you have to say on the point of registration?
On the registration, my lords. First thing, my lords, these all impugned orders were passed when I was registered. I was deregistered in, my lords, there were several Jharkhand workers union who were deregistered by one order 3/5/2017, saying that you have been depositing your audited accounts to the Bihar Labour Commissioner. So for us, you are the defaulter, therefore we are cancelling your registration.
Your cancellation was done by Bihar, not by
Cancellation, yes. So they were saying Bihar, I'm sorry, I stand corrected. The Bihar Labour Commissioner said that you are depositing your accounts and everything before the Jharkhand Labour Commissioner. Therefore, we are cancelling your registration, Millards. And thereafter, even if Millards will permit me, the Jharkhand department, government took an opinion from the Advocate General, because this opinion was given to all of us parties here during the proceedings in this honorable court on a date of hearing, Millards, when one of the honorable judges recused, saying that he was part of the opinion process. That's how we got to know of the opinion. Now, Advocate General, in his opinion, Millards, I will show, in his opinion, states that, Millards, that these unions can be regularized by setting aside the Bihar state order, because they have been depositing with the Jharkhand, and that's why. And thereafter, Millards, a public notice was issued by Jharkhand Labour Department saying that no, you do the fresh registration, for which we were not agreeable because we are a labor union registered since 1946. Now, if we now register, then we become the new entity, which will affect all our cases. Therefore, milords, we went to Bihar and Patna High Court. I'm so sorry, this Honorable Patna High Court, and milords, Honorable Patna High Court was pleased to grant us an interim stay. Now, the effect of the interim stay, milords, is currently that all acts done, milords, the time when I was deregistered, milords, gets on hold, and milords, my petition cannot be, ought not be, milords, I'm sorry, ought not be dismissed only on the grounds of maintainability. Secondly, on this, because there are three factors in my favor. Secondly, the person through which I have filed, Mr. Prakash Kumar, he was a member of the union and an employee of the Tata Motors on the date of filing of the petition. Because that is also my learned friend's objection, that he was also dismissed from employment, therefore he cannot. But if the person through whom I have filed, he was eligible to file, milords, on that date, then my petition is maintainable. Thirdly, milords, even otherwise, the argument which I had made and which was very graciously noted down by learned predecessor court, milords, of this honorable court, milords, that even otherwise, thus I am arguing against myself. The Supreme Court has said that if I am taking the welfare of the large number of workers, the registration or deregistration does not matter at all. And what is the welfare here? A collective bargaining power given under Trade Union Act. Now, if the workers lose the collective bargaining power, if, as is apparent from my learned friend's arguments, that Mia Bibi Raji, if the management is happy, if the worker union is as per the management's happiness, then very well, why? But it is not the case of happiness. It is the case of getting better bargain on behalf of workers for bonuses, for increments, for better welfare measures, for medical assistance, for residential benefits. Now, who will take care of all this? Under the Constitution and under the Trade Union Act, it's the workers' union who has been given power to take care of all the welfare measures. Now, you surreptitiously insert another worker union whose workers are, whose office bearers are in your favor. Management is very happy. I'm sorry, milords. This is not the principle of labor laws.
Yeah, ये पूछ के निकालिए 7574. See, there is, so far as this idea is concerned, there is another idea, that is IA number 11397 of 25.
25?
Yes. And this has been served on the state, right? And as per this IA, they say that the earlier IA being IA number 1361 of 2018 and 7574 of 2018 is still showing as disposed of, and therefore it should also revive. There is a separate IA to that effect.
There is no order on that.
There is no order on that.
They never pressed it. That's and your lordship will consider.
You see, recently there is a judgment also of Honorable Supreme Court that this is too technical when you say that the IA will not be.
No, someone has to press the IA.
They are pressing the earlier IA.
We have been pressing, have they obtained any order?
That IA was dismissed because the writ petition was dismissed.
I am not on those technicalities. What I am saying is, if they were interested in the IA, they ought to have 3 days it was heard in another bench. Not once did they mention about IA. And your lordship will come to election 11 of the counter.
You see, this particular IA 11397 of 25.
That has not been served on us.
You can respond to this. They will serve it. We are just wasting time.
It's their fault.
I am absolutely clueless.
And your lordship will see about the registration.
You see, I'll tell you one thing. This particular IA, you respond to this IA with the other 2 IAs also, which they are seeking for revival. You respond because unless I pass a formal order on these IAs, I will not be able to proceed. Because even if I file it, even if I pass an order, then the order will not sustain because they will say that these IAs were pending. You see, there is a problem.
Provided they press the IA, if I file an IA and I just forget about it.
not aware. कौन है आप हैं? कुछ ब्रीफ भी नहीं करते हैं, कुछ मालूम भी नहीं है, IA फाइल हुआ है आपको मालूम भी नहीं है।
Month of August 2025.
तो ये 1.5 घंटा से 2 घंटे से कौन बताएगा कि IA फाइल किया है? Who will sell this? Who will tell this to the court? You just keep on apologizing and wasting the court's time. इसीलिए ना हमको मेंशन करने पर हम ऑर्डर जल्दी से सुनते नहीं है क्योंकि हमको पता है काउंसिल्स को पता ही नहीं होता है कि रिकॉर्ड में क्या क्या है. I am aware of this. The councils are not aware that what all are there on the record and there is all likelihood that I will commit mistake. I do not hear cases without reading the brief. आपको पता ही नहीं है आपका कौन सा आईए पेंडिंग है, आपने क्या क्या आईए फाइल किया है, क्या किया है, क्या नहीं किया है, कुछ नहीं मालूम है आपको.
And your lordship will come to election 11.
You see, can I decide this case without disposing of these IA?
Probably not. But I'm just, so much has been argued by Mr. Mishra. I just want, I have shown that their registration at Patna was cancelled. They were asked to come to Jharkhand and apply. They challenged the directions given that no, that registration should come. That was rejected by single judge division bench Supreme Court. Then the matter was considered by the Labour Commissioner Jharkhand, and he gave a finding that you are not applying. What can I do?
Their problem is something else. They say that if they apply afresh, they will get a new registration number.
What does that mean?
That it will make a difference because this will not be in continuity to the earlier registration. They want a continuity with respect to the earlier registration. Had it been transferred, then they would have got a continuity. But their registration got cancelled because they did not comply with Jharkhand. And that particular order
now,
that
who is to blame?
Nobody. I'm just telling you. You have just said that it will make no difference. It will make a hell lot of difference.
No. What I'm saying is this order reject because they were registered in Patna. Now they have no jurisdiction in Patna. They were told at Patna that here are the 900 trade unions. Please go there. They gave out in newspaper. It was published. Please go there. Apply for registration. That would have recorded the whole thing. Now they did not do anything.
You see, I just cannot dispose of this petition without disposing of the interlocutory application.
That's all right.
That has to be disposed of. We can't do anything about it.
Let them serve the interlocutory applications. We'll respond.
अब सर्व भी नहीं करते, contesting party को सर्व नहीं करते. Why have you not served them? You were unaware of everything. Your clerk is also unaware as you are.
In the month of August 2025.
Why have you not served it? Yes. आप अनअवेयर हैं, आपके क्लर्क भी अनअवेयर है, आपके सीनियर भी अनअवेयर है, आपको पता ही नहीं है कि ऐसा आईए फाइल किया हुआ है.
ठीक है, मैं भी कर
इतना टाइम वेस्ट करते हैं, कुछ कहने का नहीं. हमको तो समझ ही नहीं आता हम इस हाईकोर्ट में एडवोकेट्स का क्या करें. बोलने में भी हमको खराब लगता है. आपका इतना इंपॉर्टेंट आईए पेंडिंग है. जब हम फाइनल ऑर्डर करते हैं हम लिख देते हैं आईए डिसमिस्ड एज नॉट प्रेस्ड. वो क्या करेंगे? दिस इज टू मच. After the case was heard on merits for 2 hours, for about 2 hours, it came to light that one IA number 11397 of 2025 is pending before this court. It appears that the writ petition was earlier dismissed for non-prosecution, and on the same day and through the same order, IA number 1361 of 2018 and 7574 of 2018 were closed. However, the writ petition was restored, but there was no specific order restoring the. However, the writ petition was restored, and thereafter this interlocutory application has been filed for restoration of the interlocute of the this IA number 11397 of 25 has been filed for restoration of the other two for restoration of the two interlocutory applications. Counsel for the private respondent have submitted that they neither have the copy of IA number 11397 of 25 nor they have a copy of IA number 1361 of 2018 and IA number 7574 of 2018. Counsel for the appellant is directed to serve a copy of the aforesaid 3 interlocutory applications to the counsels for the private respondents and also to the counsel for the state. State को भी serve करिए. ठीक है, ये है आपके पास. और बाकी दोनों सारे सर्व कर दीजिए by tomorrow and file the receipt regarding service upon them. The respondents may file a response to all the 3 interlocutory applications. फाइल कर दीजिए. आप कुछ तो करना पड़ेगा ना इसका. ओपन एंडेड नहीं छोड़ सकते. हाउ मच टाइम डू यू नीड नाउ? यस रिस्पोंडेंट.
Four weeks will require finally.
Just in 2 weeks we can.
You did not mention it. You were not in a hurry.
Very well.
एक चीज़ और लिखी. I'll post it after 4 weeks. You may have to respond to it also. 2 weeks time is granted to the respondents to file counter affidavit to the aforesaid 3 interlocutory application. 1 week thereafter to file a rejoinder if any. Post this case on 20th April.
Not on Monday, Tuesdays.
Okay.
Either 22nd or 23rd.
22nd April. On that day, we will hear only on IA.
It
Or
will come up in orders.
under the heading for orders in the supplementary cause list for passing appropriate orders on the interlocutory applications. Since the counsel for the parties have almost completed their argument so far as the merits of the case is concerned, they are also directed to furnish their list of dates and short synopsis of arguments, annexing the copy of the judgments which they seek to rely. The relevant provision of the Trade Union Act be also referred to in the written submissions.
Written submissions.
You please file it now. I have understood. Now I am not dictating it because of this IA.
Very well.
What about the other case? The second one connected with this? उसमें भी यही कहानी है. आप कौन है?
Second case, connected cases.
कौन है आप? How is it connected to this case? Who are? How is it connected? You have challenged the same order.
Not actually counter affidavit में same कहानी का किया टेल्को वर्कर यूनियन का डीरजिस्टर्ड है.
तो ये किस लिए फाइल किए हैं?
ये फाइल किया
इंडिविजुअल कैपेसिटी. प्रकाश कुमार.
ना यूनियन के तरफ से.
नहीं, this is प्रकाश कुमार and others.
हाँ तो हम आगे फाइल आगे फाइल करके मेमो ऑफ पार्टीज में अमेंडमेंट के लिए फाइल किया है. प्रकाश कुमार जनरल सेक्रेटरी टेल्को वर्कर यूनियन फाइल पिटीशन मेमो ऑफ पिटीशन में लिखा हुआ, बट इंस्टेड ऑफ दैट जनरल सेक्रेटरी टेल्को वर्कर यूनियन प्रकाश कुमार होना चाहिए. तो ये चीज समथिंग स्लाइटली चेंज के लिए मैंने आगे फाइल किया.
IA फाइल किया है. That you want to pursue this case in individual capacity.
Union side से, not in individual capacity. General Secretary of the Telco Worker Union, Vice President of the Telco Worker Union, and member of the Telco Worker Union filed this petition.
Do you have any objection to this?
But it's the same thing. Their telco worker union itself is there. Here the office bearers have come in a separate rate.
Yes.
For the same union.
So should we allow this IA?
What's the idea?
There is one IA. ये तो आपको सर्व हुआ है.
Must have been wrong back.
26, 17/3/26.
26.
I'm not very
17/3/26.
326.
IA numbers 3782 of 26 has been filed seeking amendment of.
That is day before yesterday.
Seeking amendment in WPC number 3209 of 2024. The learned counsel for the.
Probably we are not a party in that.
Versus Tata Motors Limited. Counsel for the State and Tata Motors Limited
Was received for Tata Motors.
are directed to file may file their counter affidavit to the interlocutory application if so advised prior to the next date.
We will be given a copy. I don't know.
It has been served on you by a copy. Counsel for the petitioner undertakes to serve a copy of the interlocutory application to the counsel for the state and also to Tata Motors Limited by tomorrow and file a receipt of service. इसमें भी वैसे ही 2 weeks and 3 weeks का order.
Obliged.